For the foregoing reasons, I'm of the considered view that the petitioner is entitled to a refund of surplus amount of rupees 2,35,70,292 as surplus sale proceeds arising out of auction sale of the tea garden of petitioner held on 7/10/2021. Accordingly, it is directed that the respondent authority shall refund the surplus amount of rupees 2,35,70,292 to the petitioner within a period of 45 days from the date of receipt of certificate of this. However, the respondent authorities are at liberty to recover any statutory dues from the petitioner as may be permissible under the law.
Item 2, WPC 1573 of 2024.
The impugned orders are set aside. The petition stands interminable. Dispose of interminable. Yes,
Memo of adjournment in respect of item number 27.
yes,
First, can it be taken up after 2 weeks also?
okay. On the prayer of Mr. M. Das, Learned Counsel, appearing on behalf of, huh?
7, 8 and 9.
So respondent number 7, 8 and 9. Let this matter be listed
My lord,
after,
I am appearing for petitioner, my lord. Kindly fix the
listed
date.
after 2 weeks. Mr. So-and-so, Learned Counsel for the petitioner is present. Huh?
Kindly fix the date.
It was fixed today. We'll take it after 2 weeks.
My lord, may I beg to mention item number 23, my lord? My learned senior friend is there here, my lord. In this case, my lord, I was supposed to get instruction. I could not get it today, my lord. Can it be fixed after, immediately after 2 weeks, my lord?
Yes. On the consent of Mr. S. Katoki, Learned Counsel for the petitioner, Mr. J. Pine, Learned Standing Counsel, NRC, pressed for and granted 3 weeks time to obtain instruction. List after 3 weeks.
May I please, your lordship? I beg to mention, lordship, item number 11, lordship, we consent to the other side. lordship.
Yes, on the prayer of Mr.
A Borua, lordship.
A. Borua, Learned Counsel for the petitioner, list this matter after.
On 11, lordship, because lordship, in this case, lordship, abstention advocacy is there, lordship.
After 2 weeks.
Lordship,
You
11,
give the
lordship,
date after 2 weeks.
lordship,
Accordingly, you fix it.
the council is lordship from out of station.
You ask him, we'll fix the date today. We'll give you a fixed date today.
13.
May I please,
Master
Your Lordship, with
Yes.
the consent of other side, Lordship, I beg to mention item number 9.
9,
Yes, Lordship. I request some accommodation.
8 and 9.
9, only 9.
No, 8 and 9 are,
7, item number 7.
yes. Yes,
Some time, Lordship.
What
For
is
the
this?
response. There's some settlement processes going on, Lordship, that's why I request some time, Lordship.
I think it's over now.
But new policies are came, so Lordship, some
Tender was in 2014 was. It's the operation of
is continuing,
continuing
the petitioner is continuing, so we want some settlement.
petrol pump,
Yes, sir, Lordship.
petrol pump.
Yes, sir.
Okay,
I'm for the respondent, Lordship.
okay. On the prayer, Mr. S.S. Roy, Learned Counsel for respondent what?
Then 2 and 3, Lordship.
Which 2 and 3?
Bharat
Bharat
Petroleum.
Petroleum. Respondent Bharat Petroleum Limited. And as consented by Learned Counsel for the release this matter after 3 weeks.
Obliging.
May I please, your lordship? My lord, I beg to mention item 8 and 9, man. I want to withdraw, my lord, with liberty to file a fresh one. If
Why?
possible. 8 and 9.
This is regarding that stone quarry.
Yes, my lord.
Stone crusher. Huh?
Yes, my lord.
Nothing is remain now.
I think-
Your everything is over.
Yes, my lord.
What,
Therefore-
what liberty you want?
If not necessary.
Anyway,
Yes.
Mr.
And Uddin.
Uddin, learned counsel for the petitioner submits that he has an instruction to withdraw this writ petition with a liberty file. List of prayer for withdrawal is allowed. Accordingly, writ petition stands withdrawn. Dispose of on withdrawal, huh?
Yes, my lord.
With a liberty as prayed for.
8 and 9 both.
Separate, will pass separate.
May I please your lordship? Lordship, I beg to mention item number 18, lordship. Better become infructuous, lordship.
Mr.
JP Moore, lordship.
JP
More,
Moore, learned counsel appearing on behalf of Mr. S. Chatia.
lordship.
Learned counsel for the petitioner submits that writ petition has become infructuous in view of above. Writ petition stands closed on having been become infructuous.
May I please your lordship?
Yes.
Lordship, I beg to mention item number 10 and 40.
And yes,
Council is out of station for next 2 weeks, Your Honor. We are appearing on, in item number 10, we are appearing on behalf of respondent number 6, 7 and 8.
then
10. 6, 7 and 8.
you are appearing on by SK Sharma,
Yes,
appearing,
GN Sahewala.
okay. Miss MS,
Sahewala.
learned counsel appearing for on behalf of Mr. G.N. Sahewala, learned counsel for respondent 6, 7 and 8. Submits that Mr. Sahewala, learned senior counsel has some personal difficulty today. Therefore, correspond listing of the matter after 3 weeks. Prayer is allowed list after 3 weeks. Then item 14,
Number 4, Your Honor.
respond number 4. You have taken the consent.
I'm for the petitioner, Your Honor.
Yes. Same order, Mr. So-and-so is
You for
present.
this on behalf of Mr. T. Deori.
Leader.
Highly offensive.
May it please your lordship, I beg to mention item number 12, lordship.
Hmm.
The writ petition become infructuous, lordship. I am for the
Same
petitioner
order, Miss MS
and they.
and the learned counsel for the petitioner submits that writ petition has become infructuous. Accordingly, writ petition stands disposed of on having been become infructuous. Yes.
May it please your lordship? Lordship, I beg to mention item number 22 of the daily list. We are supposed
20?
22, your lordship.
Yes.
Lordship, we are supposed to file an additional affidavit in this matter. Lordship, may kindly grant us some time for this.
On the prayer MS,
Behalf of Mr. H.K. Das.
please take care, learned counsel appearing on behalf of Mr. H.K. Das, learned counsel for the petitioner. List this matter after 3 weeks so as to enable the petitioner to file additional affidavit.
Please oblige, lordship.
May I please your lordship? With
Huh?
May I please your lordship? With consent of the respondent, I beg to mention item number 30, lordship, 30.
30.
Yes, lordship.
Yes.
Matter kindly adjourn for 1 week, lordship.
Why this is listed for orders for what?
Because lordship, last occasion, lordship, respondent take time to file instruction, lordship. Take instruction, but they have not filed any affidavit, lordship.
Who is for respondent?
The respondent.
You want some more time?
So we are awaiting instructions.
And Mr. So-and-so learned counsel for the petitioner. On the prayer MS, P. Upadhyay learned counsel appearing on behalf of
Lordship for G.
Mr. S.C. Care, learned standing counsel GST. Further 3 weeks time is granted to obtain instruction. File affidavit. File affidavit or instruct, file affidavit, affidavit in the police.
Interim is there, lordship.
Interim order passed earlier shall continue. Yes.
May I please your lordship? Lordship, I beg to mention item number 21.
21,
Yes,
yes.
For adjournment, lordship.
Why?
My senior brother is expert, lordship.
Mr.
M. Rahman on behalf of NJ Dutta.
M. Rahman, learned counsel for the learned counsel appearing on behalf of Mr. N.J. Datta, learned counsel for the petitioner. Submits that Mr. Datta is in bereavement, therefore fresh for listing on matter after 4 weeks. 3 weeks, huh? Praise the Lord, list after 3 weeks.
Deeply.
May I please your lordship?
Yes.
Lordship, I beg to mention item number 13, daily list 13.
Yes.
Us, little time to file affidavit in reply,
On the prayer of MS, your name, please?
behalf of MU Mahmood.
Ah,
S. Sheikh on behalf of MU Mahmood.
learned counsel appearing on Mahmood. Further 3 weeks' time is granted to file affidavit in reply.
May it please your
Obliged,
lordship.
Lordship.
May it please your lordship.
Yes.
Seek to mention item 26.
Hmm.
I'm praying for an adjournment with the consent of the other learned side.
Why?
Your lordship, my senior counsel is not well. He is suffering from severe back pain since midnight.
Who is your senior?
Debashit Goswami.
Huh?
T. Goswami,
For?
petitioner.
Petitioner. Okay, on the prayer of MS so and so. Learned counsel appearing on behalf of Mr. D. Goswami on the ground that Mr. Goswami, learned leading counsel in this matter, is indisposed. Come on, let this matter be listed after 3 weeks.
Please, your lordship, I beg to mention item 17. We have received information regarding the demise of respondent number 4. So we may be allowed some time for filing substitution petition.
Mr. on the prayer, Mr.
G. Rengma, Your Honor.
G. Rengma, learned counsel for the petitioner. Let this matter be listed after 4 weeks, 3 weeks, so as to enable him to file appropriate application for substitution of respondent number 4, who reportedly had expired.
Obliged.
So my senior is on legs before the division bench, your lordship. May I pray after some time, your lordship? Lord.
After some time. I think your part is over.
Yes, only my lord, some judgments to be.
Judgment. This is regarding
That land acquisition.
that
2013.
reference.
Definitely.
Same day, when the payment was made,
No.
the application was also, I
After
mean,
2 days.
huh?
After 2 days.
It was 14 to something
No, my
like
lord, that date will show. That was wrong.
after receipt.
After.
Lordship, that's our case.
Anyway, let's see.
Months.
Just wait. Mr. Talukdar, this item 2, which I disposed of today, I tried, but then I find that except for not naming in the FIR, I find the impugned orders perimeteria. And as a judicial discipline and propriety, I had to. Same deputy commissioner, same order, right?
Only difference is the FIR name.
FIR name. So until, but that's why we given the same order passed by the coordinate bench that the liberty has given to take, initiate further action.
In spite
If it is found guilty, because the criminal case is pending.
then we have
So as you say that, I mean, the accused is
found involved or.
and until it is proved guilty beyond reasonable doubt, he is presumed to be innocent. So that context, but basically on the I found that
My
it's a fair. I have recorded everything. You have distinguished, I mean, made an good attempt to distinguish. That also I have considered. I have recorded, but then tried my best to give the justification.
I'm obliged.
Yes, yes.
My lord, here in the case, the respondent authority allowed us, my lord, 2,000 of bigas land we are numbering about 300 people, 300 families. In the year 1944, my lord, that page will, lordship will find at page 46, my lord. Did that
Mr.
deputy-
Goswami, are you ready? Page 40?
46, my lord.
Huh.
Here, my lord, please fix up a date, my lord. We have filed a petition, and thereafter on that petition, the DC ordered that please fix up a date within next week. Also with SDC Kamrup and visit Dokhania PGR. They are allowed to have about 2000 bigas in either Dokhania number 1 and number 2. Next, my lord, these people have been evicted and should be given land. Please come up with the file regarding de-reservation PGRs urgently to direct them to settle and must have pending formal orders.
But this is what this is this is
Thereafter, my lord,
office note,
my lord,
internal
yes, that was,
communication,
yes, my
office
lord.
note.
At that time, that was order, my lord. Accordingly, we are allowed to settle. Thereafter, my lordship will file 47. At that time, some of the petitioners, some of the settlers filed objection that that land was not suitable for residential purpose, so we may allow to another land. Thereafter, this notice was, my lord, page 47. It is hereby to inform you that land measuring 200 bigas situated in Dokhania Reserve is open for you. It is not true that the said is not fit for cultivation because the said land situated in northern side is fit for residential purpose and the southern side is fit for cultivation. It may be mentioned here that you have denied to settle, therefore apprehension of life is completely false. If there is any other reason for apprehension, the government will take necessary action. So it is hereby again ordered to you that the Deputy Collector of the Kamrup Circle will hand over, show the land at present during flood season, occupy that Tapabari area instead of old place and occupy the said land. It is to be mentioned here that the person who willing came to this new place during the flood season with their bag and baggage within 31/7/47, then government will bear all expenditures. So what happened, by this way we are
These are all type copies, Lordship. Originals are
We
there,
were-
Lordship.
settling
These are
there.
all type copies, Lordship.
But this case was of the 2000 from case was going on from 2000 and several lead petitions were filed, my lord. At that time, it was not required, my lord. At that time, it was not required. Otherwise, case.
Where is the original? This is type copy.
My lord. Thereafter, my lord.
No, I'm asking. What is the original? This is type copy.
Yes, my lord. My lord, this case was from 2001. My earliest says about that copy was in the hand of the some earliest sets of advocate, my lord. I may be allowed to place my case. Thereafter, my lord, if it necessary, my lord. Thereafter, lordship may peruse, my lord.
No, if it is a type copy, if you have not annexed the original, whatever may be, how do we, accept this? Then
Yes,
how
sir.
do we proceed?
My lord, from 2001, there are 5-6 petitions. All these petitions are disposed of, my lord, on the basis. At that time, it was allowed. Presently, it is repaired and copy. So, my lord, at present, some copies are in my hand, some copies are in the earlier stage of advocate. Let us, my lord, place my case, my lord. Thereafter, lordship may peruse.
Okay, we'll definitely allow you to place your case.
Yes, my lord.
But then until the first documents which you have you're relying, if there's no original, how
My
do we rely?
My lord, thereafter, there is my lord, communication of the government also, my lord. Lordship may,
You have been evicted.
Lordship, yes.
yes, my lord, we have been evicted.
Hmm.
Only there is a puzzling, my lord. That will
Puzzling.
be clear,
What puzzling?
clear from my lord. There.
What do you say? What you have said?
My lord,
Only there is a
There is a puzzling between the revenue village. Lordship will find it at page
Puzzling.
86. Page 86, my lord. One
80.
revenue village named 2 number Dukhania and another revenue village named Dukhania number 2. These were, my lord. There are similar.
With due respect, it is to inform the I alone field inspection of encroachment of Dakunia grazing reserve along with the concerned Lord Mandal as directed by you in the above mentioned letter and on inspection. It is found that in Dokania number 2 grazing reserve, there were about 15 encroachers occupying the reserve land illegally by constructing a house and by doing cognizance. Along with this report in the trust map, the said encroached land of grazing reserve had been shown by making with red ink. A list of encroacher is also enclosed. You are the alleged encroacher.
No, my lord. We are the resident of serial number 2, name of village. 2 number Dukhania. And we are also allowed 2 number Dukhania. At that time, my lord, 1944, my lord, 1944, 47. But my lord, the
Before independence, during independence.
thereafter also, my lord, we have my lord, another, I am placing, my lord. Lordship will find page 77, my lord.
You have been evicted from Dokania number 2.
Yes, my lord, but thereafter I filed contempt. They submitted that we are not evicted from Dokhania, 2 number Dokhania, but Dokhania number 2. Actually, we are not Dokhania number 2. We are in 2 number Dokhania. It is the order of my lord 2010.
2010 or 14?
My lord, 8/4/2010. my lord. Here, 1,000 bigger was allowed, my lord, as per the order of this honorable High Court.
Let
my lord.
notice. What is this? But subsequent river eroded land. This is what? Page
Page 77, my lord.
77. What does it say?
Annex 20.
What does it say? This is to inform you that the land measuring 1,000 bighas in number 2 Dakania, Pasim Bansur was hereby hand over to your possession. Nabojoti Krishak as per order from the office of the Tribunal. Your Nabojoti
Yes, my lord. All are the
Krishak
Amarpur
Unnayan
district.
Samiti.
Yes, my lord.
Huh?
My lord, Manipuddin was the secretary, my lord.
Two number Dakania.
My lord. Number 2, Dokhania.
So what do we want to say?
But they are evicted from this place. But report submitted before this honorable court that
So according to you, there are 2 places.
2 million. Not
areas.
only 2 places, but another.
You have
One-
been evicted
The
from
place named Dokhania, there are 4 also, my lord. If lordship went through trace map, my lord, last trace map also, it seems there.
one by one, sir. Tell us. Don't jump here and there.
Also Dokhania number 4, also Dokhania number 3.
Are you concerned about which Dokania?
My lord, we are about Dokhania, number 2 Dokhania.
Then you come. Then according to your number 2 Dokania or 2 number Dokania?
My lord, number 2 Dokhania, 2 number Dokhania, Dokhania number 2. When it was written, they have written 2 number Dokhania, and I reflected number 2 Dokhania, but their name is Dokhania number 2. Dokhania number 2, first Dokhania, next number 2. And our place is number 2 Dokhania. Yes,
So you have been evicted from
from our place number 2 Dokhania.
number 2 Dokania or 2 number Dokania?
My lord, That's number two Dokani and two number Dokani in same
Exactly, you
village.
yourself is puzzling.
It's same village. Number two Dokani, two number Dokani, same village, but Dokani number two is another village.
So how you can be evicted?
My lord, they have issued notice, my lord. And then subsequently they are evicted. At that time, there is the order of the Honorable God High Court, and that Guwahati High Court protected us. Page 80, my lord.
Status quo. It is a status quo.
Page 80.
Yes,
Yes, my lord.
in the interim, the status quo for impugn evictions notice so and so shall be maintained until the returnable day.
Yes.
Dismissed lordship.
Huh.
On 28/9/23, this matter is dismissed for non-prosecution lordship.
Thereafter, already we have evicted.
They
Yeah.
have already affected and this matter.
Thereafter evicted matter is already infectious
Ah.
before dismissal, my
Ah.
lord. Now this petition is for, my lord, restore to our possession, my lord.
No, no,
This-
once it's, you are evicted, you have not pursued that matter and you are happy, you have not filed any restoration and or
My lord-
you have not filed any appeal,
My
how
lord-
can you file a fresh petition?
My lord, this petition, after eviction, this petition is filed.
Therefore, you cannot be, because you have challenged that eviction.
Yes.
I mean, notice,
Firstly, I have challenged the eviction
Eviction
notice by
notice.
this petition.
then
Subsequently, with, interim order, though there is an interim order, but they evicted
interim
us.
order is what? The status quo.
Status quo, my lord.
Now, then,
When, my
when
lord, they have
ultimately
already
writ
evicted us.
petition was disposed of.
Yes, dismissed.
My lord, when they have, my lord, evicted us.
Where
my
is
lord,
the dismissal?
Only did,
Lordship, actually, I have taken the online lordship. It is dismissed on 28/9/23. This is get in the lordship.
My lord-
Dismissed on 28/9/23. I have checked.
When did you file this writ petition?
my lord, this petition,
This is filed on
this
18th.
petition was filed 18, my lord. This
Then?
one, this one 18 after eviction, my lord.
Ah.
After eviction, though that petition was pending.
You
subsequent-
bring that copy. See, now basically you are saying you have filed a writ petition 2018,
Mhm.
right?
My lord.
That writ petition, that is 2014, you have filed a writ petition challenging the notice, right?
Yes, my lord.
Challenging the notice
Yes.
of eviction, right?
Yes, my lord.
Thereafter,
After we have evicted.
when the matter was pending,
That was pending, we have evicted.
You have-
Certainly, that writ petition infectious, my lord.
evicted. Then,
That is why, my lord, that writ petition was not restored. Now subsequently that before pending that writ petition, my lord, I filed this petition,
But
present
order is-
petition.
Order is there, lordship. Dismissal order is there, lordship.
see, your prayer was uh, to restrain the authorities from evicting them from the land in question. Right?
Yeah.
Nobody pursued, nobody appeared for it. Right?
My lord, to the present petition and that writ petition was come that day analogously, along with the contempt case also. Subsequently, what happened, my lord? I filed restoration and restored this present petition. I restored only present petition because when already then when already matter was infectious, my lord, that matter, as we are already evicted, so matter, though I pursue the matter, then also, my lord, it will be infectious.
Where are you now? How many persons are here now, presently?
My lord, presently, file,
8% lordship. 8%.
8 persons, though we are 8 persons on behalf of 300 people, that was, my lord, it's annexer 1, my lord. Is 34, my lord.
You read your prayer, page 29.
In the grievances aforesaid, it is therefore prayed that this honorable court may be pleased to admit this writ petition, call for the records and issue rule calling upon the respondents authorities to show cause as to why writ of and or any other suit order as directions of the case in nature should not be issued. The impugn action of the respondent authorities in evicting the petitioner and all other persons as mentioned in the list by annexer 1 to writ petition from number 2 Dokania Revenue Village under Pochim Bangshar Mauja within the jurisdiction of Hazo Revenue Circle, Kamrup.
Despite the status quo there.
Despite the status quo order dated so and so, passed by this honorable court in WBC number so and so, now pending before this honorable court for final decision as the impugn eviction notices so and so, to be illegal, arbitrary, discriminatory, unfair, and unconstitutional effect from using deliberate and willful contempt to the court and or as to why a writ and
So
or
now
the-
pending before this honorable court for final decision as impugn eviction notice, that has been already disposed of. You have not pursued that matter.
Another thing was that coming to the respondent to restore possession of the
There
petitioner.
is
by
writ
allowing
petition
them to
3081.
enjoy the possession. my lord.
Hmm?
This petition for my lord, directing the committing the respondents to restore the possession of the. petitioner.
Basically, there was a status quo order, interim order in 3081. Now this has been disposed of.
My lord, here we are, my lord, prayed for restoration mainly, my lord. Mainly
How?
already we are.
How the eviction, the basis, the foundation has been already been removed now. So obviously, this is a superstructure
My lord, on the basis
which
of the-
automatic will fall.
On the basis of, my lord, permitted, admittedly, or order, my lord, permitted us, we are not encouraged, sir, my lord.
Huh?
We are not encouraged, sir.
Why not, I mean, interested now? Because you have challenged the eviction order
Yes, my lord.
that has been disposed of, dismissed,
My lord.
right? You have not pursued that. Now, until we find that the eviction order is bad or whatever, we interfere, which you have pursued, not to pursue on your own volition. How do we know that, how to direct you to restore your, I mean, how we can pass a direction to restore? Because you were issued notice. You were issued notice, you were put to challenge,
Yes, my lord.
and it is in dismiss, you are happy, you have not pursued.
No, my lord, my lord. there,
So
all
therefore,
it-
I'm saying, the foundation of your case was the eviction. You have challenged that.
Yes.
It has been removed now. Court has directed that there's nothing remains. So you have already
My lord,
evicted. Now, until unless we decide the issue of the eviction notice, which is no longer there. So this is a superstructure. Restoration is a kind of superstructure which automatically falls.
land is still there vacant, my lord.
Hmm?
Land is vacant. The, my
We
lord-
don't know.
My lord, and we are, no, my lord, that PGR land was.
We don't know. Now the legal issue, I mean, the issue was you have challenged the eviction notice. It was that writ petition has been dismissed and you have filed this petition for restoration, obviously. Well, unless we say that the eviction notice was, or we interpret the eviction notice, how can we direct the restoration?
My lord, my presumption is that when the case was, my lord, already infructuous, when writ petition, we have challenged notices.
Yes.
And they have, on the basis of notices, we have already evicted us.
Yes.
I think, my lord, nothing remains in.
So this, you have challenged the eviction and that has been dismissed.
Already we filed contempt also, but we have filed contempt also.
Where is the contempt?
My lord, that was dismissed, taking the plea that, my lord, Respondent number 3 submitted the report. No, we are evicted from Dokhania number 2. We are evicted from Dokhania number 2. So our place is 2 number Dokhania. And that is why,
How do we decide whether it is Dokhania number 2 or 2 number Dokhania? And you have not annexed documents which you are relying, the original documents. Only you have received.
my lord, then I may be allowed, my lord, to file that original documents if my lord is able to, my lord, and statement and my lord. I may be allowed to file documents. Some documents is in my hand, my lord, and some.
No, this writ petition, what will it be, this? We
my
cannot
lord,
restore now.
No, yes, my lord, I may be allowed to restore it.
How can you?
My lord, I may file, my lord. I have filed only this petition. Both petition were,
What is
lord,
the other writ petition?
and this one and another writ petition was,
3081, 2014.
yes, my lord, both are analogously, my lord, dismissed by single order, my lord, same order. This present petition also dismissed, my lord, by same order. But present writ petition also dismissed by same order, but I have restored it, my lord.
Where is that order?
Huh?
Twenty-three four.
Restoration petition, my lord, I am placing, my lord. That was
23/4, 2025.
2375 or 2025, my lord.
Yes, same order that has been restored. This writ petition has
Yes,
been
my lord.
restored. By 23/4/2025.
Both are analogously listed and both are, I filed on
Same order,
restored petition, my lord, same order.
similar order.
By similar order, my lord.
So according to you, since it has become infructuous, you have been evicted, you are challenging the eviction only. Not the issue, notice. It was notice.
My lord.
During the pendency, it was,
But both
you have
are
been
under
evicted. Therefore, you have filed this petition.
My lord.
Same order,
Same order, my lord, analogous.
very material. But then it has been dismissed wrongly, I mean restored wrongly or rightly. In any case, what do you understand?
File on affidavit, lordship.
My lord, already they have filed affidavit, my lord, on my lord. Lordship will file page, my lord, their affidavit in opposition.
No, they have filed the affidavit, let them say.
My lord. Okay.
Why you should be allowed to submit everything?
My lord.
Yes.
That 2 number Dokonia, lordship, that is PGR land, lordship, and another part is general government land, lordship. So there has been evicted, lordship. There is a PGR land and some of the government land, lordship. That is why they have been evicted, lordship.
He said there are 2 plots, I mean 2 areas. One is number 2 Dakonia, other one is 2 number Dakonia. This yours is number 2 Dakonia.
My lord.
And the report says that it is number 2 Dakonia.
Dokhania number 2.
Dakonia number 2. Number 2 Dakonia.
No. According to our affidavit, lordship, 2 number Dakonia is a PGR land, lordship, and it is a government land, lordship.
Which they are which they are,
No, my lord, they are
which
report,
they were occupying.
already, my lord, I have placed before lordship that, that is clear.
They are
what
not
is the-
occupying 2 number Dokani, your lordship.
Very difficult. Where you have
Page
stated,
86 will clear, my lord, that is their order, my lord.
where you have stated,
There are 4 more evidence of it.
There's common order, dismissal, common order. Common order, total common order, একই order. এটি হেরি করেছিল। ওটা সালে না order টা। ওটা order তো সালে। আছে তো প্রেজেন্ট আছে দেখে।
heard Mr. Swenson, learned counsel for the petitioner, and Mr. N. Goswami, learned counsel for the state counsel for respondents. Henry, you are also appearing.
One.
Henry Swenson.
One is four.
The petitioners have filed this writ petition for restoration of their possession of the land from land, namely your land,
M. Hussain, my lord.
your land,
Land, my lord, number 2 document.
number 2 Dakonia village. Two number Dakonia or number 2 Dakonia?
My lord. 2 number Dukonia, number 2 Dukonia, same place, my lord. Only Dukonia number 2 is another place, my lord. Dukonia number 2.
List of from number 2 Dakonia village. List of the state from which they have been already evicted after issuance of notice, which was the subject matter of writ petition, the WPC 3081 of 2014, which has been dismissed by an order dated 2809/2023, huh? Perusal of the affidavit in opposition filed on behalf of the state respondents indicates that there is no villagers in 2-number Dakunia village. And the said 2-number Dakunia village is free from all sorts of occupation from all sorts of encroachment, public occupation from any corner. List of considering above, who is the authority here? Circle officer, huh? The deputy commission, district commissioner of what?
Rural.
Kamrup within Berkut is directed to pose an inquiry to the concerned officials or officers as regards the claim and counterclaim with regard to the number 2 Dakunia village and the
And Dokania number 2.
Dakunia
Number 2.
list of the report be submitted for this court for proper education, for appropriate education within 4 weeks. List the matter after 4 weeks. Let us see.
Highly author.
Met please, your lordship.
Well,
The other day, I placed the facts.
Yes.
Still, my lord. to
I just
refresh-
wanted to know what is that
My lord,
date of payment and
Yes.
the application.
Yes.
You just so.
If your lordship would kindly come to page number, my lord, 86, my lord.
86.
No, before that, I'm sorry, my lord, 1 second. Just give me 1 minute's time, my lord. Excellent. Yes. May I just place the facts once again, my lord, just to refresh everybody's memory, my lord. Now, there was a proposal for acquiring the land in question. My lord, there was no compulsion on the part either of NRL or for the state of Assam to go for this land, because other lands were also there. Therefore, in a peculiar fact, lordships will kindly appreciate at page number 61, the estimate was approved on 16th of July 2021. And listen, my lord, the government of Assam in the revenue and disaster management is writing to the deputy commissioner. With reference to the subject cited above, I am directed to forward herewith an approved copy of land acquisition estimate amounting to 79-odd crore. Then my lord will kindly come to next page 63, Now, Office of the Deputy Commissioner is writing to the Numaligarh Refinery. With reference to the above subject, I am directed to enclose herewith a copy of the letter dated so and so, along with approved copy of land acquisition estimate amounting to so and so rupees, and arrange to deposit the same by check, banker draft to the Deputy Commissioner. So we were told that this is the land acquisition estimate, therefore make arrangements to deposit the amount. Then, my lord, at page number 65, Numaligarh wrote to the Deputy Commissioner, my lord, on 27/7/21, with reference to the above enclosed, please find herewith a bank draft bearing so and so. So, my lord, entire money was deposited at the disposal of the Deputy Commissioner's establishment. Then, my lord, at page number 74, now Deputy Commissioner's office wrote to the my lord, respondent number 3, at page 74. Now, this is 18th of September 21. With reference to the subject cited above, I am to inform you that Numaligarh Refinery Limited Authority has deposited an amount of rupees 79 crore and odd, only being the cost of land and Jirat in regard to LA case number, which has already been deposited into the savings bank account of Deputy Commissioner. Therefore, before releasing the amount of land and Jirat in regard to the above mentioned LA case, you are requested to hand over formal possession of 600 bighas to the Numaligarh. Now, my lord, the respondent number 3 response via letter dated 24/8/21 at page 67.
Yes.
24/8, with reference to the above, we are ready to hand over advance possession of the land to the Numaligarh Refinery Limited. Now, please come to the last para. Meanwhile, my lord, the status of the respondent number 3 changed. Therefore, they said that the payment has to be released in the name of the changed entity. Otherwise, in principle, my lord, they agreed to hand over possession of the land. When
Yes.
does one agree to hand over the possession of the land? They are, my lord, convinced with the compensation which has been awarded. Then, my lord, the Deputy Commissioner writes to the, my lord, respondent number 3 at page number 76.
Yes.
Now, there are certain formalities which are to be observed in connection with payment. Therefore, my lord, Deputy Commissioner's office wrote to the respondent number 3, please provide indemnity bond, Jamabandi copy, Khazana receipt, and account details, including so and so. So that, my lord, through RTGS, the money can be deposited. In the meantime, my lord, at page 69, the formal award is issued, passed. The Deputy Commissioner forwards the formal award to the, my lord, Deputy Commissioner's establishment at page 69 on 17/11/21.
Yes.
Then, my lord, pursuant to the letter of the Deputy Commissioner, at page 78, the respondent number 3 furnishes the indemnity bond and other requirements which were called for. Page 78. This was on, my lord, 22nd of November. Then at page 84, my lord, Lordship will find there was a meeting of the stakeholders which was attended amongst others by the Chief Minister also, where, my lord, a decision was taken that the handing over and everything would be ensured according to the decisions already arrived at. Then finally, my lord, kindly see at page 86, that this date is very crucial in this case, 19th of February 22. Now, the respondent number 3 is writing to the Deputy Commissioner. The release of compensation with reference to the above and discussion dated 3/2/22, which was, my lord, held under the chairmanship of CM, and as advised in the meeting dated 5/2 so and so, chaired by Honorable CM, compensation amount can be released after deducting the amount payable to eligible workers. So 19/2/22, finally, my lord, they said, all is well, deposit the money in our account. Then, my lord, this was on 86. Then, my lord, will kindly come to page number 88. This is a notarized affidavit of respondent number 3, my lord, on 10/3/22. On oath, they say release it.
Yes.
The Deputy Commissioner Golaghat may release the compensation amount payable to the aforesaid LLP against LA case number so and so for acquisition of land measuring 16 bighas being acquired for Numaligarh Refinery Expansion Project after deducting therefrom the amount of compensation payable to the eligible workers as per MOM dated so and so and as advised, etc., etc., etc. So on oath they say, we are agreeable to everything, please release the money. Now comes the twist at page 90. Now, mark the date, my lord. It is 14th of March 22. With reference to the above and against the acquisition of land measuring 600 bigha out of the land measuring so and so in the district of Golaghat, an amount of rupees 63 crore 39 odd deposited through online transfer in our bank today. That means they received the money on 14/3/22. What they say, my lord? We confirm the receipt of the above amount under protest as to sufficiency of the amount without prejudice to our right. So for the first time, my lord, on 14th of March, after on 19th and 10th of March, on 19th they gave the undertaking, and my lord, on 10th they sworn the affidavit. On for the first time on 14th, they say we are accepting the money, but under protest. So this is what they would like to ignite, my lord, in the form of a reference. But, my lord, there is a catch to the whole thing. Please come to page 91. There is no dispute that the money was deposited on 14th. Kindly see, my lord, on left-hand side, there is an endorsement by the Office of the Deputy Commissioner. This is 16/3. So, in effect, this letter was on 16/3 after deposit of the money on 14/3. From this perspective also, there was acceptance and the protest is post-acceptance. Not only in principle, but money was received on 14 by their own account, but this letter was sent on 14. Merely writing 14 will not do, my lord. What will matter is, I think the records will also testify that it was on 16th. That, my lord, this endorsement is there. Therefore, on 16th, they wrote this letter. And from the very beginning, they have been. Now, this is the factual matrix, my lord. Now, I'll place the legal position. Land equation yeah.
I have a copy.
So it was received on 16.
It was received on 16, my lord, by the Office of the Deputy Commissioner. So after deposit of the money on 14th, এখন আছে পুরনো এখন আছে নতুন এখন দিয়ক 13 Since most of the decisions are on section 18, which is perimeter to Milord section 64, therefore I am placing section 18 first, Milord. Please come to section 18. Any person interested who has not accepted the award may, by written application to the collector, require that amount matter be referred by the collector for determination of the court whether his objection be to the measurement of the land, amount of compensation, person to whom it is payable, or apportionment of the compensation amongst the persons interested. So my humble understanding, as also has been, my lord, explained by the Honorable Supreme Court, this recourse to section 18 of the old act and section 64 of the new act, my lord, can be taken resort to only when the award is not accepted. Then my lord will kindly come to section 31 of the old act. I'll come to the new act, my lord.
Yes, yes.
Please come to section 31 of the old act. On making an award under section 11, collector shall tender payment of compensation awarded by him to the person interested, entitled thereto according to the award, and shall pay it to them unless prevented by some one or more of the contingencies mentioned in the next subsection. If they shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to title to receive the compensation, or as to apportionment of it, the collector shall deposit the amount of compensation in the court to which a reference under section would be submitted, provided that any person admitted to be interested may receive such payment under protest as to sufficiency of the amount, provided also that no person who has received the amount otherwise then under protest shall be entitled to make any application under section 18, provided also that nothing therein contains shall affect the etc. etc. So, my lord, only one who has accepted under protest, he alone is eligible to lay a claim under section 18, now section 64. Now, please come to section 64 of the new act, my lord.
Yes.
Any person interested who has not accepted the award may, by written application to the collector, require that matter be referred by the collector for determination of the authority as the case may be, whether his objection to the measurement of the land, amount of compensation, person to whom it is payable, rights of rehabilitation and resettlement under chapter 5 and 6, or apportionment of the compensation among the person interested. So, my lord, there is an angle of proviso also. I'll come to it little later, my lord. Let me first deal with section 64 first. So, what clearly emerges from section 64, which is perimeter to section 18 of the 1984 Act, my lord, a claim or a reference under 64 to the authority would be maintainable only when, my lord, and the award is accepted under protest. Now, in the present case, my lord, I have already demonstrated there is absolutely no element of any protest. On the contrary, my lord, they filed an affidavit. They sworn an affidavit on 10th of March saying money can be deposited. My lord, if they would have not agreed, we could have negotiated with somebody else. But it's end of the day, it's a public money, my lord. It can't be somebody's, my lord, mercy or somebody's, my lord, discretion. Now, please come to me, Lord, section 77 of the new act.
Yes.
77. On making an award under section 30, collector shall tender payment of the compensation awarded by him to the person interested entitled thereto according to the award and shall pay it to them by depositing the amount in the bank. Same as section 31, my lord. Kindly come to the second proviso, which is perimeteria as section 31. Last second proviso, provided further, no person who has received the amount otherwise then under protest shall be entitled to make an application under subsection 1 of section 64. So reading, my lord, section 64(1) and second proviso to section 77 subsection 2, what clearly emerges, as has been held by the Supreme Court, is that, my lord, such a recourse can be taken resort to only when the award is accepted under protest. After having accepted the award, my lord, this does not lie in the mouth of any claimant. Now, my lord, let me place some case laws on this point. There are unanimity of the Supreme Court except for one judgment, which I'll place, my lord, Ashwini Kumar Dia, Ajit Singh Dia, Warrington, land acquisition officer, Sababi.
So according to you, unless you
Protest
protest or
before acceptance,
decided not to
Accept.
accept the award,
you cannot raise this.
there is no question of
Entertaining any claim for reference.
received and say that I received it under protest.
Yes,
It has to be read together.
yes. Before that. Before that. In fact, before. My lord, I'll place few case laws, my lord, I've given in seriatim. Please come to this first judgment, 1992, 2 SCC 592, paragraph 10.
Yes.
1992, 2 SCC 592. The acceptance of compensation under protest was not done by the appellant with a view to safeguard his right to challenge the acquisition itself, but to safeguard his right to require the matter being referred by collector for determination of compensation in relation to the matter mentioned in section 18 of the Land Acquisition Act. It is clear from the provisions of section 18 of the Land Acquisition Act that the person interested, in order to enable him to seek the remedy of reference, can do so only if he does not accept the award. If, in other words, to show that the person concerned had not accepted the award, the claimant accept the compensation only under protest, because once the compensation awarded in pursuance of the award is accepted without protest, the person concerned may lose his right to a reference for various matters mentioned in section 18 of the Land Acquisition Act. So, my lord, the Supreme Court's understanding of section 18 is very clear. In order to enable an interested person to maintain a reference, he must accept the award under protest, or he will not accept the award. In that case alone, my lord, he will be eligible to maintain a reference. Then, my lord, will kindly come to the next judgment. My lord, this 1994 4 SCC 67, I'll place it little later, my lord. This is the only judgment where contrary view has been taken. I'll come to that also, my lord. Perhaps my learned friend will rely heavily on that. Next, my lord, will kindly come to our High Court judgment, my lord. It's a matter from our High Court, 1995 4 SCC 428. 1995 4 SCC 428.
Yes.
Please come to para 5. There was a division bench High Court judgment of our High Court, against which, my lord, the matter was carried to Supreme Court, and Supreme Court has passed this order. It will thus be clear that persons interested in land are entitled to receive compensation awarded by the collector under section 11 under protest, and entitled to object to the compensation determined by the collector. No person who had received the amount otherwise then under protest should be entitled to make the application under section 18. In other words, the receipt of the amount under protest is a condition precedent to make an application under section 18 within the limitation prescribed under the proviso to subsection 2 of section 18, together with the grounds on which the objection has been taken. Therefore, collector is enjoined to make a reference to the civil code with the statement in the manner stated in section 19. So this is also a clear authority for the proposition.
Even without going to the,
What to?
the last line, sir, without going to the matter,
What to do?
the last line.
Good.
The judgment will come last time, without going into, even without going.
But for a moment, if your lordship would also have paragraph 6, my lord, last 3 sentence.
Even with.
Even without going into the merits, we hold that the finding of the High Court that reference application itself is not maintainable is perfectly legal and does not warrant interference. Now I'll place our High Court order, my lord, which was dealt with by the Honorable Supreme Court in this case. Yes, sir? Yes. My lord, that FA number 36 of 92. Please have, my lord, that judgment, my lord. Collector, Mauck Road Subdivision versus Warrington Lingdo. Guwahati High Court judgment, my lord.
Okay. Yes.
Please come to page 16, my lord, of the judgment. This was the judgment which was upheld in that 1995 4 SCC.
16.
On top, my lord.
Yes.
Having considered all the matters from these angles and having perused the materials on record, and after hearing the learned counsel of both the parties, we hold that as the compensation award was accepted by the claimant without protest, they have no right to claim for enhanced rate under section 18 of the Land Acquisition Act. And in that view of the matter, the special judicial officer had no jurisdiction to enhance the claim as done by him in the reference number so and so, so and so. So this was, my lord, judicial primature was given to this view of our High Court. Then, my lord, the next judgment is 1997 9 SCC 710. (Clear) 1997 9 SCC 710.
Yes.
Para 9, my lord. No doubt, they have filed the writ petition in the High Court for seeking reference. But the High Court's order was only for making reference on verification and to find out the correct factual position. The official himself was in collusion with the claimant, and without making any inquiry, he made the reference. Subsequently, some persons were impleaded to the reference. That itself indicates that all was not going well. Now, this is the legal position. It is now well settled position in law that claimants who receive compensation under protest and who make application under section 18(1) alone are entitled to seek reference. Third parties who have been impleaded have no right to claim higher compensation by circumventing the process of reference under section 18. Under these circumstances, reference itself is without any jurisdiction and barred by limitation. Thereby, the award of the reference court is clearly illegal. On appeal, the High Court has not considered all this perspective and found it convenient to rely upon another judgment to uphold the award of the civil court. The appeal is accordingly allowed. Then, my lord, please come to this famous case of, my lord, Indore Development Authority, 2018 3 SCC 412.
Yes.
Para 12. Now, I'll invite your lordship's kind attention to the passage between placetum D and E. The sentence starting with the collector is required. Has your lordship got it, Miller?
Yes.
Between placetum D and E. The collector is required to deposit the amount of compensation in court to which a reference under section 18 would be submitted. It is also provided in section 31(2) that no person who has received the amount otherwise than under protest shall be entitled to make an application for seeking reference under section 18. It is open to a person under first proviso to section 31(2) to receive the payment of compensation under protest as to the sufficiency of the amount, and such person is also entitled to maintain a reference. The third proviso to section 31(2) makes it clear that any person who has received the whole or any part of the compensation awarded under the Act shall still be liable to pay the same to the person who is lawfully entitled thereto. It is with the purpose as provided in section 31. When the amount is tendered, it can be accepted under protest and still a reference can be maintained. In case awarded amount has been accepted without protest, reference cannot be maintained under section 17. Now, my lord, I am pausing here for a moment, my lord. Coming back to the facts of the case, when we wrote this letter, my lord, now if your lordship would kindly take the pain of coming back to the facts once again.
I think this was taken to the larger bench,
Which one, my lord?
Indo Development Authority.
Indoor.
But the fact remains same.
No, my lord, this position remains unaltered. Now, my lord, if your lordship would kindly come
If I correctly remember, or if I am not mistaken, I think this
Indoor
indoor,
Development Authority, yes, lordship is correct. And my lord, to our.
maybe on a different point.
Yes,
I
yes,
mean,
correct.
regarding, I think, section 24.
Correct.
But I'm also not sure. We'll have
Yes.
to find it
No,
out.
we'll find out, madam. We'll find out and let your lordships know. Now, my lord, now please come to February order to court goes.
1,
Ah.
2,
Now, my lord, please come to page number 11. Yes, please come to page number 11, my lord, 84.
of writ petition.
Sorry, 86.
Of writ petition.
Yes, my lord. 84.
Where is the other judgment?
I'll come to that, my lord. The Kerala High Court judgment is there and one Supreme Court judgment is there. My lord, just to, my lord, put the facts in perspective, my lord, I'm referring to this. Now, this is a minutes of the meeting held on 5/2/2022, held under the chairmanship of the Chief Minister. Meeting was held in continuation to the meeting under reference and will supersede the related points in the meeting. It is agreed by Raspberry Tea Company, that is Mosak, to provide an amount of 4 lakhs only to the
I'm sorry,
permanent.
which page?
Yes, page 84, my lord.
84.
Ah.
Yes, we have read last
Yes.
time also.
Now, my lord, pursuant to that at page 86, kindly, this is very important, my lord. Therefore, whether they have accepted the award or not, for that I have just placed this.
Yes.
Now, the respondent number 3 is writing to the Deputy Commissioner. Subject is release of compensation.
Amount can be released after
Yes,
deducting.
without reference to the above, as discussed in the meeting dated so and so, compensation amount can be released after deducting the amount payable to eligible workers. So they have accepted the award. Where is the protest?
Just a minute.
Yes.
What I have seen from the Supreme Court judgment,
Yes.
it clearly says that until unless you receive the amount under protest, there cannot be a reference.
There cannot be.
Simple as it is.
Yes.
But it is, we are dealing with a matter which is more beyond.
More beyond, much beyond.
Because much beyond, in a sense,
Yes.
that according to you, unless the award is, if you don't protest the award, there's no question of
Make a
accepting
payment.
it under protest.
Yes. Correct.
First, you have to protest the award.
Precise.
Then only when the amount is received, amount
Yes.
paid,
Yes.
if you accept, then only there is question of protest. Then
Yes.
you can receive it
Yes,
under protest.
precisely, sir.
That is the
Now,
issue.
my lord, there is one judgment of the Supreme Court
Yes,
which strikes a discordant note. I'll place that.
yes.
This is 1992, 2 SCC 592, para 10, which I think they will be relying, my lord.
1992?
Huh?
592.
Eto nohoy niki?
1994.
Sorry, I'm sorry. I'm
Four
sorry.
SCC.
I'm sorry. Ajit Singh hai,
1992.
Ajit Singh to hai.
1994.
Hobo, hobo.
1992.
Ah, I'm sorry, my lord. 1994, 4 SCC 67. Please come to, my lord, paragraph 5.
1994.
Yes, my lord.
Ajit Singh.
1994, 4 SCC 67.
Hmm. Para?
5.
Yes.
Having regard to the contiguity to these lands, the High Court is correct in its valuation. Besides, the date of notification issued under Section 4 is October 478, while Exhibit R6 is nearer to it, namely August 16, 1978, in comparison to Exhibit A6 dated January 14, 1977. So this was in the context of the facts of the case. Inasmuch as the appellants have filed an application for reference under Section 18 of the Act, that will manifest their intention. Therefore, protest against the award of the collector is implied, notwithstanding acceptance of the compensation. So, in this case, my lord, Honorable Supreme Court has tried to, say that the moment we file an application under Section 18, manifestation is already there. Therefore, whether we accept the award or not, the moment we file an application under a reference under Section 18, then, my lord, protest is implied. My lord, this is the only one of judgment. I have read the judgment which are all post this. In none of the judgments, my lord, the judgment was referred. Now, my lord, a full bench of the Kerala High Court had the occasion to deal with the judgment. We have placed their judgment, my lord. No, basically this is Ajit Singh. Now, my lord will kindly take their judgment. That is 2000 Supreme Kerala 392. We have given that judgment, my lord.
In this case, whether the protest was filed before the
After.
protest
In
was
fact,
filed.
in
Yeah.
fact, my lord, it was
Here.
after. Yes, yes. Now,
After
this is
receipt.
the only one of view. No other cases, lordships will find where the Supreme Court. Therefore, my lord, in my humble submission, my lord, it's a judgment per incurium, my lord. It's a. In a High Court, I cannot argue that the view of the Honorable Supreme Court is wrong, but it is incongruous, my lord. At least going by the, my lord, doctrine of stare decisis, lordships can ignore this judgment. Because there has to be, my lord, certainty in law. One of judgment cannot upset the, my lord, the judicial momentum.
Thereafter, a lot of judgments have come.
Thereafter also, my lord, series of judgments are there where, my lord, Ajit Singh was never referred. Now, please come to that Kerala High Court judgment, my lord, para 20. Facts to key. Please come to para 16, my lord. Page 390. No, it will keep on. Page black nothing.
Internal page 8.
Internal page 9, my lord. 9 of 35. 9.
16.
Yes.
Yes.
Internal, yes. In Ajit Singh, has your lordship got it?
Yes,
my lord?
yes.
In that's the case, the claimant accepted the amount awarded without protest, but later made an application for reference under Section 18 of the Act. On a reference, the additional district judge declined to grant the benefit of enhancement to those claimants who have received the amount of compensation without any protest. In para 5 of the judgment, the apex court, there is an observation as under. Inasmuch as the appellant have filed an application under section 18 of the act, that will manifest their intention. Therefore, the protest against the award of the collector is implied, notwithstanding acceptance of the compensation. District Judge and the High Court fell into error in denying the enhanced compensation to the appellants. Consequently, the appeal was allowed and the appellants who had not lodged any protests were also held entitled to the enhanced compensation. In Warrington, that's 95 Milord, that Shillong case, award was made on 17th of May 89. Appellant received the compensation on 5th of July under an agreement Exhibit B, which was signed by them and the collector. Thereafter, on 8th of August, they objected to the amount of the compensation determined by the collector and claim enhanced compensation by way of reference. On appeal by the state, High Court reversed the decree of reference court and held that since the claimant had agreed in Exhibit B and received the compensation subject to the terms and conditions in Exhibit B, they were not entitled to make an application for reference. In our case, my lord, there is an affidavit on oath. Here it was Exhibit B. In Agreement B exhibit, they had stated total amount of compensation arrived at is fully acceptable to us. A contention was raised before the apex court that despite the agreement Exhibit B under which compensation was accepted, there was later on a protest and hence application for reference was maintainable. The same argument was not for maintainable. Constructing the scheme of the provisions of section 31 read with section 18 of the act in para 4 of the judgment, apex court held in para 5. No person who has received the amount otherwise then under protest should be entitled to make an application under section 18. In other words, receipt of the amount under protest is a condition precedent to make an application under section 18 within the limitation prescribed under section proviso to subsection 2 of section 18, together with the grounds on which the objection has been taken. Thereon, the collector is enjoined to make a reference to the civil court with the statement in so and so. So emphasis is ours. Then, my lord, Sibaya's case is referred. Then, my lord will kindly come to para 20.
Yes.
In view of the discussion in Warrington's case and Sivabai's case, it is now well settled position in law that claimant who receive compensation under protest and who make an application under section 18(1) of the act within the prescribed limitation alone are entitled to seek a reference. It is not as if the claimant can receive the compensation without protest and subsequently make an application for reference under section 18 and contend that making of an application under section of the act itself manifests his intention and therefore he must be deemed to have accepted the compensation under protest. To that extent, now this is very important, my lord, the observation made in para 5 of the judgment in Ajit Singh's case, so and so, are not borne out by view expressed by the apex court in two subsequent decisions. So full bench of the Kerala High Court was of the view, my lord, that the observation in Ajit Singh's case that filing of an reference application post acceptance of the award per se constitutes and manifests intention. Therefore, section 18(1) can be invoked, was held to be, my lord, not borne out by the subsequent decisions of the Supreme Court. So in any case, my lord, a later Supreme Court judgment must prevail. In admitted facts of the Ajit Singh's case, the claimant had not made any protest when they received the amount of compensation. A ratio of the decision in Warrington and Sibabai would clearly show that person who had not objected or protested at the time of receiving compensation are disentitled to make application for reference under section 18. In our view, such construction is also borne out by the provisions of the Act. So I think, my lord, though it is a judgment of Kerala High Court, my lord, nevertheless, it has persuasive value in my humble submission, my lord. And the view appears to be consistent with the, my lord, contemporary view of the Honorable Apex Court on the issue. The
Yes.
one-off case is only Ajit Singh, my lord. And
That's why I said,
yes,
said that clearly so that persons who had not objected or protested at the time of receiving the compensation are entitled to make an
Precisely.
application. So this is, okay, I've understood.
Ah.
But present case is something
yes, much above that.
much above that. So,
So that is my humble submission, my lord. The other point is on limitation, my lord. Moreover, this claim is not on limitation also. Despite that, my lord, how the learned court of the learned district judge allowed this petition, I don't know, my lord. Therefore, lordships will set aside both the orders and reject the application under section 64 read with section 77. Now, if a lordship would kindly take the 2013 Act, my lord. While opening the argument, I said I'll deal with the, my lord, limitation point later on separately. Now, please come to, my lord, the third proviso of section 64.
yes.
Provided that every such application shall be made, person making it was present or represented before the collector at a time when he made his award within 6 weeks from the date of the collector's award. Now, collector's award in this case is, my lord, 17/11/21. If it is 17/11/21, my lord, 6/6 will take us to 28/11/21. Now, assuming for the sake of argument, my lord,
6 weeks,
6 weeks. 6 weeks will take us to 28/11/21.
No, if it is 17, 11,
Here
20,
in
21.
this case, my lord, they filed it on 16/3/21, 22. কোনটো?
No,
Huh.
see, if the award was at 17, 11, 20, 21,
Yes,
then it has to be from there, 6 weeks.
28/12/21.
That's why I'm
I'm
should be
sorry, my lord.
not 11,
Yes.
12.
Ah.
Yes.
Now, my lord, admittedly, they filed it on 16/3/22.
Hmm.
That application at page number, my lord, 91. Yes. Now let us come to the other provision, my lord. In other cases, third proviso B, in other cases, within 6 weeks of the receipt of notice from the collector under section 21, or within 6 months from the date of collector's award, whichever period shall expire first. Now, regarding the collector's award, it is 28/12/21, my lord. Now, 6 months from the date of collector's award, it takes us to, my lord.
Which expires first?
Which expires first? 6 months will take us to Kimano, but I think it should be, my lord, 10/5/21.
20,
20,
then 5.
22.
সেইটো পিছত যাব
Ah.
সেইটো whichever expires first.
Whichever expires first.
Third case is within 6 weeks.
So their application is 16/3. Money was received on 14/3. Approval was given March on February. And the affidavit is dated 10th of March.
2022.
Yes.
Within 6 weeks of the receipt of the notice from collector and a
Whichever is earlier,
or within 6 months from the.
whichever expires first.
Yes.
Then, my lord, kindly come to the third proviso provided further that collector may entertain an application after expiry of the said period within a further period of 1 year if it is satisfied that there was sufficient cause for not filing it within the period specified. Admittedly, they have not availed the benefit of this. So, my lord, that is over. So therefore, my lord, my humble submission is, one, it is barred by limitation. Second, it's an open and shut case where, my lord, they having accepted the award without protest. And if you go by the language of section 18 and, my lord, section 66(4), it is very clear, only when you do not accept the award, then only you are releasing. Here in this case, no question of accepting, my lord. They have done everything, including swearing an affidavit, asking the authority to release the amount. Money was released. They formally acknowledge the receipt on 14/3, but on 16/3, they say we are accepting it under protest. So that being the factual position, my lord, the impugned order which has been assailed in this case are all, my lord, in nullity, and those needs to be set aside. End of the day, my lord, these are all public money. It can't be a fun at somebody's instance.
Where is the award?
Yes. That is in the form, my lord.
Referred by the
Yes,
the
my lord,
deputy
yes.
commissioner.
Page number 769, my lord. Actually, I think the government will be able to produce from the record, my lord. Page 69, Deputy Commissioner is forwarding it to the, my lord, government in the Revenue Department. Form 10, award list.
Only one.
Huh?
It implies under section 31.
Yes.
This is an award under 31.
11. Earlier section 11,
Now
now it is 11, no? 31.
2021, obviously 31. Not under section 69.
Nice. Lord, this provision has an objective, my lord. It is a case where, my lord, only a single tea state is involved. There are cases, my lord, where hundreds and hundreds of people are involved. Supporting land is acquired for construction of a road. If this is what something is permitted, then there will be no end to it, my lord. So this, there is this provision which has been incorporated. It has an objective to achieve. And most importantly, my lord, if they would have said we are not agreeable, then we would have explored with somebody else, because Tata Tea was already there in the lineup. So that is my humble submission, my lord. And lordship will also guard the finances of the state, my lord. It is not just file a piece of paper without any legal sanctity. Or maybe they are fence sitters, we don't know.
Deposit of the award is only section 77,
Yes.
not before. No other section. Take.
I'm deeply obliged. So lordship's kind permission, can I take?
Yes, yes. Yes.
Well, with regard to the point of limitation and the issue that my learned senior has brought it out, Your Lordship may acknowledge one fact that reference proceeding is pending. The issue as to the validity of a protest, whether there is no dispute that there is no protest. What my learned friend is, senior is arguing is that the protest is not a valid. It ought to have preceded the receipt of the money or immediately at the time of receiving the money, I should have protested. Now that.
No, when
is-
when he read the section 64, what he said is that what he has submitted is that first you have to,
Accept the award.
I mean, protest, oppose the award. Then only the protest comes.
With regard to 77 is receiving the amount under protest. Accept the award is one aspect in 64. 64 does not talk about saying that I need to protest with regard to the amount given to me. But there is a condition in 77 proviso which says that the amount has to be received under protest. My first leg of submission is this, that these are questions of facts. There is a Supreme Court decision, Your Lordship. I'll just,
You first read section 64. Reference is under section 64 only.
Right.
Yes. Let us read again.
any person interested who has not accepted the award. Now.
They could able to establish that you have accepted that award.
The award comes, Your Lordship.
Page 90.
No. The Assam Act, the rules provides that where the amount is more than 5 crores, it has to be approved by the government. That came, Your Lordship, I'll give you the relevant dates.
Have you made any this your affidavit?
I have not filed an affidavit because this is a question of facts.
So
All the documents are there already.
question of facts can,
Additional, we have filed a limited.
sir, question of facts too, you have to file.
No, we have filed an additional affidavit where we have brought the award and the approval accorded by the government. That your.
If it is a question of law, you may not to be required. But if it is a question of facts, you have to brought in the record.
We have brought because all the records. and-
When was the award? Then tell
Annex of 5 page 39
239,
of our
239. There's again another, the double this thing, pagination.
It was initially marked as 234, then 234 may be seen.
229.
34, it may, 239. 239, no, no? Yes, Your Lordship, it's 239. This is the approval accorded, of which no copy has been marked to us. That's our case.
Two-
Even the notice
239
9.
approved award, huh?
This is the approval.
I'm directed to forward you did an approved copy of the award amounting to same amount.
No, the other amount is. What the amount is going to select? 67. What award to? Same amount, no, different. Here in page 65, the amount is 79 lakhs, here is 75 lakhs. It's like crores. The rule that I'm referring to is 30 sub rule 5.
Of what?
Assam right to fair compensation rules. Assam Right to Fair Compensation and Rehabilitation Rules 2015.
And
35. If the total amount of compensation to be paid is more than rupees 5 crore, prior approval of the state government shall be mandatory before declaration of the award.
So that has been approved.
Approved.
Yes.
Division bench has said, when it is approved,
Hmm.
the division bench of the Guwahati High Court,
Hmm.
in its decision of 24/3/2025, has said in view of the fact situation, when the award signed by the district collector was approved by the state competent authority on 9/1/2014, then the same became an award only on 9/1/2014, as laid down by the Honorable Supreme Court in Bailama so-and-so case.
আমার হাইকোর্টের অর্ডার নাকি আমার হাইকোর্টের
Oh.
কোন কেস
With State of Assam versus Ananta Ramnath, on the date of Ananta Ramnath.
Why you have accepted in 19 February?
That is
The
an offer, that
compensation-
is not even an offer. I've been only been intimated.
The
Your
com-
Lordship, what has happened is this.
Page 86, please come. Is your letter only?
Yes, I said, give it the money.
Yes, release of the compensation amount can be released after deducting the amount payable to eligible workers.
Right, Your Lordship. I agree with that, but that is only the compensation. I'm not saying that I'm accepting the award.
Huh?
There's not a whisper on that. It's like a final bill. You're paying me, asking me for a no claim certificate. Even a no claim certificate I can withdraw. And the Supreme Court is clear on this line, Your Lordship. Your Lordship, the Supreme Court has, what my learned senior was submitting, that there is no Supreme Court judgment with regard to following Ajit Singh. Our division bench in 2018 has approved that. And it, as regard the Guwahati High Court position, Your Lordship, I will directly go on this protest case then. To this one. So
Are you
number
saying
40.
that, sir, are you saying that you need not protest the award?
Even if I don't need to protest. There are decision, I have prepared.
Forget the
compilation.
decision, let us see, reference is made under 64, right?
Right, Your Lordship.
Then 64, what 64 says?
Acceptance of the award.
Any person interested who has not accepted the award
My.
may by written application require that the matter may referred by the collector for determination of the authority in case, as the case may be, whether it's objection to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of the so and so. This, you are not accepting the amount of the compensation.
Your Lordship, this is like this.
Quantum you are not accepting.
The quantum I'm not accepting. I'm accepting, one is in the initial phase is that, am I objecting to the acquisition process? I say I don't.
Ah.
One is the compensation. An award is an offer. Unless and until that offer is made to me, I cannot convey a protest.
You have this.
Now-
and
now-
one page 86. But reference to our discussion MO so and so and as advised in the meeting so and so at NRL guest chairman chief minister so and so, the compensation amount can be released after deducting the amount payable to eligible workers.
I'm saying, you pay me. You are anyway taking advance possession of my land.
You
pay me
cannot
the
be like that.
compensation. Your Lordship, if you are-
You know that what was the compensation amount when you accept that, when you say that it can be released?
I know roughly. I know roughly.
Then
I don't know the calculation in the basis of what is the land valuation they are giving to me. A copy of the award was not even furnished to me. Let the government give me a notice.
No.
Show me when the notice was given.
that you have not protested. That's what I'm saying.
Protest, what is the time when I need to protest? Your Lordship may tell me that.
No. For reference, you need to you should not accept the award. You have accepted the award.
No, the award has not even come on 86. I've shown the approved is of that award has not come.
How can you say that? How can you, without accepting? How can you say that the compensation can be released?
I say whatever you have determined with that. accept
No.
it.
You have not said so. You
I
read this
said
page
26
86, please.
compensation.
What is not your? I mean written. We cannot just read into.
Right. So Your Lordship
Please read
also-
it, sir.
Right.
Please read it. One could understand if you say that I need not, maybe correctly, or will determine on that, will adjudicate on that. If you say that no protest, no objection with regard to award is required. Only the only protest is at the time of receiving the amount. If you say so, one may understand. But simply you have said all along, you said release the amount, we are giving all those documents which is required for releasing the amount. Thereafter, you just receive the amount, then just said we are receiving it under protest. I mean, it's not, it cannot be. Because section 77, if I prima facie understood, has to be read in section 64. Section 64, there are certain contingencies. First, you should not, if you are not accepting the award, number one, as regards the, what do you call it? Number one is the objection to the measurement of the land, you have no objection. The amount of the compensation, you have no objection. The person to whom it is payable, or the resettlement, rehabilitation, resettlement. It appears to be afterthought. Somebody has
No.
made
Your
them,
Lordship,
made them wise.
Your Lordship, may I just,
Out of records, I'm saying. Just say.
Your Lordship, my understanding of these provisions are this. The Land Acquisition Act, as per the Supreme Court, I have compiled all the judgment from 1902 to date 2025, which says that there is no mode, time, and manner prescribed of laying down a protest. The Supreme Court and even our Guwahati High Court is of the view that the mere fact that I file and seek a reference is a protest. It's an implied protest.
That is Ajit Singh.
So if your lordships uphold that view that has been laid down by the Honorable Guwahati High Court, saying that an implied protest is also applicable, in that case, whether I have protested, whether 14.2 is there, 14.3 is there or not,
That is
my very fact of seeking a protest,
That is exactly precisely a reason I had to make an observation, I mean, make a comment that all along you are happy. But when you come to know, there is decision of the Supreme Court. The moment you protest, it manifests. When you file an application, any stage, then it manifests that you are under protest. You receive the under protest.
on a basis of a mere presumption or on the basis of an evidence. Now, the reference court can go
We're
into
not
that
going to
question.
evidence now. It's not a question of now dealing with that. Obviously, they can look into it. If we say that this can be allowed, of course, subject to filing an appeal against our order, right? The issue is you submit your own thing, make your submission. I'm not stopping you. Just don't jump to the place, Supreme Court judgment. Definitely you'll be given a chance to place it. What I'm concerned is, maybe I'm wrong. My understanding of the law may not be wrong. I'm yet to determine finally. Where reading of section 64, first say that if interested person, anybody interested in the matter has not accepted the award, then under it is 2-3 contingencies. I mean, in the reasons, whatever, on the grounds, 3-4 grounds, the reference can be filed, right? Then what I think is the reference is made under 64. It has to be read with section 77. When finally payment is made and you protest, receive the amount under protest. So it has to be read conjointly.
Absolutely right. Yeah,
Otherwise, if we read section 77 only, you may be correct. At the time, the moment you receive the amount, you say that I received it under protest. Matter ends there. Then you file a reference. There's no issue. If it is your submission, we will determine it. Is not it? So what I wanted from you is that, is it enough? You receive the amount and say that I'm receiving it or accepting it under protest, as provided under section 77. Without considering that the reference is made under section 7, even if reference has to be made under section 64, which provides that award, if you are not accepted the award on certain grounds, then only reference can be made. If that is your submission, we'll record that and we'll decide.
Your Lordship, yeah,
I would like to know.
yeah.
Sir, I'm not objecting that your submission is
No,
not correct.
no.
I'm trying to
It's
understand.
just a
I'm trying to
discussion.
understand, yes.
Yes, even I'm trying to understand.
Because what basically they have said, the senior council has submitted, if I correctly understood, that unless you protest or object the award, on the, considering the factual, position in this matter, that all along you have not made any protest or objection to the award. The moment you receive the award, then you just simply write that I received the under protest. That is not suffice. That would not be sufficient to make a reference. That is what he said. On that, you just make a submission.
It can be, do I take some time to?
No, continue.
Yes. Your Lordship, first of all, what is the stage where I raise my protest?
Yes.
This is what your Lordship will have to find. My reading of the act, except at the time of issuance of the first notice, publication, with regard to the acquisition process, initiation, whether it is for public purpose or not. After that, there is no scope to raise a protest except me raising a claim. I give a claim. Then the collector gives his offer as to what will be the cost of the land acquisition in the form of an award that we call it, as the Supreme Court has also interpreted, it has to be the offer. Once that offer is made, then only the question of acceptance or not accepting arises. Because in a contract, it's nothing but a contract. It's an offer of sale and I'm accepting it or not accepting it. So unless and until that award comes about, the offer comes about, I don't require to raise any objection to it.
I beg to differ. In the land, especially particularly 2013 Act, it's a beneficial legislation. There's no question of offer. It's a rehabilitation and resettlement, basically.
Right.
Once the award is passed, only requirement is, as per the provisions of this, you'll have been given notice on all this rehabilitation, all these other things has to be done. Then only you have been given the award would be passed. And there's a provision which has been provided to beneficial for the party interested or the affected party. Then they have been provided an adequate safeguards and a mechanism to protest or object the amount of the quantum of amount, rehabilitation, whom it is payable, so far as the measurement. It's not a question of offer and acceptance. This is, I think, I beg to differ. Anyway, let us not go into that. That will be unnecessary where we're diverting the issue.
Now, 64 is a place
Yes.
which says that if you have an objection as to, or you do not accept the award, partly, nothing is mentioned. Not accepted the award. Now, is there for?
In respect of a 3 or 4 grounds.
Yes, 3 or 4 grounds.
Let us see, first ground is whether his objection to the measurement of land, amount of compensation, that is quantum, right?
Yes, quantum.
The person to whom it is payable, the rights of rehabilitation are unaccepted for or appointment of compensation among the person. 4 grounds.
4 grounds, right.
On these four grounds, if you don't accept the award on these four grounds, a reference can be made within the specified limitation period, whatever, right?
Now, what I'm thinking of here, my submission is that when do I raise this objection?
Huh.
The act does not give the timeline. Prior to, after, or simultaneously.
It gives
Where? It gives
Proviso.
in section 77.
proviso.
No, provided that the. client-
Provided collector shall within a period of 30 days from the date of receipt. Government fails to make such reference within it, then the application shall state the ground on which objection to the award is taken, provided that each application, every shall be made if person is so and so. Third proviso. Two,
This is the.
subsection two, proviso one.
Ah,
That's what I'm saying. You have to make within this limitation.
Right, now the limitation.
We'll not go into that. When you say that there's no, and what time and limitation is not, by that's why I'm just referring.
Limitation as regard making the application seeking for the reference. What subsection 2 talks about is the limitation with regard to the time period for seeking a reference.
Yes.
We are not there. I'll come to the, because my learned senior has also submitted that my application is barred by limitation because I could not have even sought for a reference. I'll come to that step. I'm now in the thing about what is the time when I raise my objection with regard to the acceptance of the award. My submission is that the factum of me seeking an application to the extent of requiring the collector to refer the matter for adjudication by the reference court is an objection as to the acceptance of the award. The mere factum of me seeking a reference conveys that I am objecting as to the award. There is no prior, there is no subsequent me.
That is Ajit Singh's case.
Ajit Singh says that the mere factum of filing an application seeking a reference is an implied protest. And that is also the stand adopted in 2018 by our division bench, saying that this is a protest. 2014, 3 judges bench, what my learned has relied upon the other Supreme Court decision. Supreme Court, the 3 judges bench have taken the view of Ajit Singh. So the larger bench taking the Supreme Court decision that will govern the field. Our division bench, Your Lordship, I prepared a compilation of all the judgments, Your Lordship, for ready reference.
You see the Supreme Court judgment? So the Supreme Court judgment only. Which year? After all the judgments referred by Learned Senior Counsel.
2015. Your Lordship, in serial number 11, page 13.
Page 30. Retaram.
Yes, Sundarban versus Ghaziabad Development Authority reported. Serial number 11. Your Lordship, copy?
Page 30.
1-3. Yes.
1-3. Page 1-3.
The principal contention urged by learned counsel for the GDA was that since the compensation was accepted by the claimant without any protest, the reference was not maintainable. In our opinion, the contention is without any substance for several reasons. In Ajit Singh and other versus State of Assam and others, it was held that since the appellant therein had filed an application for reference under Section 18 of the Act, it is manifested that their intention. Consequently, the protest against the award of the was implied, notwithstanding the acceptance of compensation. Similarly, in UP State Industrial so-and-so, it was held that the question whether the compensation offered was accepted without protest is essentially a question of facts to be determined on the basis of the evidence on record. On facts, it was held that in a decision where that there was nothing to suggest that the claimant has accepted the compensation without protest. In so far as the present appeal are concerned, although the state judiciary did ever in its written statement that Chandrabhai had accepted the compensation without no issue was framed in this regard, and therefore there was no question of any evidence having been laid to show that the claim was accepted without any protest. That apart, the assessor gave his award on 7 December 1990, and Sundarban had filed his objection to the award and sought a reference within the prescribed time for making an award, making an application under Section 18 of the Act on 11 Jan 19. His conduct clearly shows that the award passed by the assessor was not accepted without protest. This is the first two judgments your lordship may see. First is Ajit Singh, that is at page 1 I have referred to. All the hard copy, I'll furnish your lordship.
Judgment.
Yes, sir. To show only the factum, I'll segregate it out, your lordship. It's a to show what my learned senior was saying that Ajit Singh is a singular instance. I'm there to show that it is not the case. Your lordship may just see page 18 once, serial number 14. Page 18, serial number 14 may be seen, your lordship.
Page 18.
This is the division bench judgment, which is now holding the field. Mr. B.D. Das, learned senior counsel for the respondents, on the other hand, contends that the respondent, by making the application dated 7/17, had expressed his intention that he has not accepted the award, and secondly, as the payment was offered to the respondent by the latter, therefore the claim for enhanced coverage by the respondent was within the prescribed time period. Mr. S.K. Medi, learned additional advocate general, in order to substantiate his consent, has relied upon the pronouncement of the Supreme Court rendered in Aswani Kumar Dhingri, which my learned senior has relied, wherein paragraph it was held as under. I'm not taking your lordship, has gone. 11. Mr. B.D., next page. It is 18 to- Your lordship, my attempt has been to show that Ajit Singh has been consistently followed all along till 2025 year.
Till 20?
till 2025.
Yes.
Your
Where's the Supreme Court? 25 Supreme Court.
No, not also, I'm showing.
Other high
one
court.
Other high courts and all, and you also in one case, which is in 23. Where the court has got to the extent of saying that even after a perusal of the order impugns shows that the amount of award was directly credited to the account of the petitioner through e-payment. Our case also the same. Depositing amount through e-payment cannot be taken as an acceptance of the award by the petitioner. Petitioner has filed an application under in such situation could only have forwarded the reference to the competent owner while submitting his comments under SOA.
We'll have to see what was the factual that thing in that on those cases,
I can do that.
because all along you have not protested, objected to the award.
Till 42,
Only,
not 43.
huh?
43, I have given a letter of protest. 14th of March 2022, I have given a letter of protest. After the amount was credited to my bank
Yes,
account.
you are accepting it under protest. That's all. Before that, you have not done anything. So according to you, it is not required.
Not required.
The moment you file a protest petition in terms of Dajit Singh, I mean the reference application, it's manifest that you are not accepting. And it would amount to receiving the amount under protest, which would entail you, which will allow, which ensure your right to, file a reference. Yes.
So if your lordship says that my 14.2 is not correct, valid, then also I'm saying that my mere action of seeking a reference by filing it within the period of limitation entitles me for seeking a reference
In view of Dajit Singh.
in view of it. And there are other cases which says that
Whether it's when did you file the reference?
reference was initially rejected by the collector.
No, when did you file?
I'm giving the date.
Award, you first tell us the award.
Award, your lordship, will be effective. My submission is on approved on 2nd March 2022, but no notice or copy forwarded to me. The government has to establish when it has done. If it is
2nd March 2022, approved.
approved.
So
No.
this will be a date for date of award,
Date of-
according to you. Then
Then it was not forwarded to me. I learned about it. On 14, the money was credited to my account. I raised my objection on
what-
14.
Second tree,
Second 3 was the
2nd
date of,
March.
2nd March is the date of approval of the award and has to be taken as the date of award.
So 14, you file a protest petition. I mean, the receipt under protest.
Yes.
Then when did you file the reference?
18-4, page 93, annexure 20, brief petition.
Just wait, receipt. The protest. Then reference.
I sought for reference on
Application
10-4, 2022. 18-4,
18/4.
annexure 20, page 93.
18/4. 20.
2.
So is it within 6 weeks? Within 6 weeks?
No, 2, no, 2, 4, 6.
Within 6 weeks?
Since
From the
it
date
was
of
not passed
award.
in our presence, we will get 6 months time.
So you, according to it, 6 months.
Government has also not objected with regard to limitation. That was not the ground on which they have rejected my first application.
No, when you have accepted when under protest, why did you file it on 4th?
Because we didn't get a copy of the
March,
award. We
April.
didn't know what is the calculation and
April.
anything. We didn't get the copy of the award, your lordship. Taking out the copy of the award took us some time. It was not furnished to us. Those are matters we have, will take it up in evidence. There before the reference court.
No, issue is whether you could have, seek reference only on the, on the, after you have received the amount under protest, under protest, without protesting or objecting the award. That is the issue he had raised.
The case law that are.
So according to you, no protest is required so far as the award is concerned. Only when you, no, even if you don't protest in terms of Ajit Singh, once you file a reference, it manifests your seeking reference, manifests your
Intention
to object
to imply.
or protest received under protest.
That's.
All right. Otherwise, in your case,
I have.
you have raised an objection. I mean, you have received the amount under protest, which entails you to seek reference. That is what you are saying.
That's your lordship.
But
has got
still,
it.
I am not convinced. How can we read? If we read only this subject to Ajit Singh and the decision. But then how once you if we read only section 77, then you may be whatever. We cannot ignore 64.
64, your lordship.
You have to protect. You have to seek reference under 4 conditions. On under 4 grounds.
Four grounds is not the issue.
And that too preceded that you are not accepting the award.
Wait for an example. What is the form? What is the conduct? So the conduct of me raising an
See,
objection
all
is the
along
application.
you have been given
That-
notice. You
that-
said yes,
That
deposit. You
the
can, you
court will
deposit,
have to look into.
not
your
deposit. You said you release it. You release it. These are my documents.
What do I?
You release it. The moment you get the amount, you said, I am receiving under protest.
All these facts will.
Can
come to
you,
trial.
could you not have said while you were corresponding in this page 86 and all that, subject to the protest, you may deposit the amount subject to the, that you could have aid.
I tell you, still minister intervened. I should have been taking this step.
Then,
What has happened?
then why you have accepted? Who has forced you to accept?
I'll not open. There, I'll not.
You should not open. You cannot open also. When you have voluntarily said that as per the decision of the, request by the chief minister, you please release the amount. We are ready to accept. Then
Your lordship, but
one fine day,
I.
somebody injected you. No, you could not have did. You could have, got more. You could have. You could have received more amount than the award, the compensation which you have received. Then it gets clicked.
Your lordship, only thing your lordship will have to. look
Anyway,
at whether that conduct will.
let us do one thing. I have tried to record it, but then for the convenience, you file a written submission.
My lord. Without, and.
And I request, these are all too many cases.
Your lordship,
Let us not trouble all of us together. Not only this court.
I'll just give the reference. At least the Guwahati High Court and the Supreme Court.
No, whatever you would like to rely, but you just say that.
I'll give a heading and then. put it.
Yes.
Your lordship,
You just give the synopsis.
My lord.
The written submission.
My lord.
Short note.
Your lordship, can I do it
And
on?
annex those judgment which you
My
are
lord.
relying.
By,
But I'll consider which is relevant,
absolutely, absolutely. Your lordship.
not all the cases.
Your lordship, can I, request for 11th of Feb by 11th?
No, you file by tomorrow. Any file? Maybe by Tuesday.
Tuesday, I'll do it.
Tuesday, we'll just fix it for submission.
My lord.
All right?
My lord.
Submission of retainer. We'll not say anything.
My lord.
We'll just fix them.
My presence will not be,
Huh?
I will not be here. My colleague will be here.
No issue. Only for submission of, you do want to have any reply? No.
No, let it be only written argument, Your lordship. Only written and submission will.
Mr. Ken Chaudhary, learned senior counsel assisted by Mr. A.K. Sahiwala,
Madam.
learned counsel for the petitioner. And also had Mr.
Senapati.
Who else are there?
Government is there.
Which one? Which one? Huh? J Hindi, revenue. Standing on J and you are two. And Goswami is lens for this and Senapati three. Correspondent with three, huh? List the matter again on third, huh?
Third.
03/2020. Or no,
Let's come up on second.
second,
This Monday.
Discord will not be here.
Oh.
Or fourth,
Six.
anyway, sixth.
Six, I have some difficulty. But submission
Or make it five.
Six, four is okay, my lord. 5 and 6, I am again outside.
So make it four. You
Four,
try.
my lord. Four.
Four. Here, just hearing concluded, judgment reserved. However, list the matter. Again, no, will not say judgment reserved. Hearing, will not say. Hearing to continue on list again on so and so, huh? We'll just simply say that with an understanding that we'll conclude on
My
that.
lord. Written submission.
That also can be done.
That can be done. As well.
Hearing
We'll do it on.
concluded, judgment reserved.
My lord.
By Tuesday you submit.
My lord.
Monday, Tuesday, whatever.
My lord.
Here.
Mansur.
Noted. And also let me see. There are so many. Last thing.
But in this case,
This one. EBD.
in this case, my lord, BTC has been recently included, my lord. Their stand is more necessary in this matter. my lord.
So this thing will be required.
The BTC has
Affidavit
already
would be
included, my
required.
lord.
Affidavit would be required.
Yes, my lord.
Affidavit would be
Yes, yes,
required.
BTC's affidavit.
Heard,
will-
Mr.
T. Chakraborty, my lord.
T. Chakraborty, learned counsel for the petitioner. You are for? BTC. Mr. So-and-so, learned counsel appearing on behalf of Mr. A.K. Buya, still learned standing counsel BTC. Press for and is granted for the 3 weeks time to file affidavit.
Your Lordship,
3 weeks.
Lordship, I humbly pray that we have been recently engaged as a standing counsel of BTC. So the
So
copies,
3 weeks.
there has been difficulty of receiving the copies. So I humbly
I'll
pray.
furnish,
the
my
other-
lord. Earlier it was furnished, I'll furnish once again.
Learned counsel for the petition, Mr. Chakraborty, learned counsel for the petitioner to file, to furnish a copy of the writ petition to the learned counsel for BTC
But
during
can I
the
date-
course of the
The
day.
date may be fixed, my lord.
During the course of the day.
It's a case of 2020, my lord. Therefore.
Yes, so
uh,
what is the matter?
my lord, regarding land was taken away, annulled, Patta land was annulled for non-payment of land revenue.
Okay.
That the petitioner's name, fathers was the owner, registered owner. But
During the lifetime of your father, it was,
yes, my lord. But thereafter, my lord, land in the meantime, it went to BTC. BTC was initially not made.
then in that case, 4 weeks, this, give the date.
My lord. 26. I'm deeply obliged.
Like.
That's one phone number. Here I pray for some time, Lordship, and for respondent number 4 and 5.
Your CJC,
Standing Council, Prince-George Municipal Board.
non appears for the petitioner on call. On the prayer of Mr. S.S. Roy, learned Standing Council,
Municipal Board.
Insecure Municipal Board. That this matter be listed after 4 weeks, so as to enable 3 weeks. Mr. Roy to file affidavit. Affidavit.
Item 15.
Yes, municipal. No, the revenue and office of the deputy commissioner. Have you filed the affidavit? Non appears for the petition on call. Last time also, nobody, none had appeared. Hmm? What is the matter? Let us give one more chance, final chance. Non appears for the petition on call. Then consent with the state respondents. No, the MSN Bordoloi. Respondent, Legislating Council for Respondent 1 and 2, and Mr. S.S. Roy. Then State Council. Granted 3 weeks time to file affidavit.
Item 16.
Your lordship, the item has become infructuous due to paucity of facts.
MS,
It has
your name
become
please.
Name.
Prachi.
Give your name. Appearing on behalf of
JC Gore.
JC Go.
J.C. Gorland, Counsel for the petitioner. Petitioner submits that writ petition has become in process. List of accordingly, the writ petition stands close on having been become in process, huh?
Item 19.
The kindly ask about the matter for the time being.
What is the matter?
I don't have the brief. My senior is at other court.
Any affidavit? Will you give some time because they find out whether they are entitled or not. And Mr. So-and-so learned council for the, on the prayer, Mrs. S.S. learned council, learned state council for that. 3 weeks time is granted to file affidavit.
Obliged.
Item 20.
Twenty. Yes, this is what?
But if this matter, he is not entitled, lordship, because MSC appeal, the vehicle number is there, lordship. So he has to file MSC appeal. That's why he's.
Last occasion said the issue raised in the present is pending before division writ appeal. Saying what?
Already sanctioned.
Hmm?
The appeal and that money was already sanctioned by the CEO lordship. On that ground only the appeal got postponed.
The legal issue was not.
Otherwise,
Otherwise also they
this case is not maintainable because the vehicle number is there, he has to identify it. He has to file MSC.
page number 6, paragraph number 3, the details is given up regarding the vehicle, your lordship.
Just wait.
It's a dumper.
Non appears for the petitioner on call. Matter pertains to claim of ex gratia compensation amounting of rupees 2 lakhs on account of the death of the husband of the petitioner in a road accident on 27/05/2022. Before that, you write N. Bordoloi and S.S. Roy, standing counsel and so and so. Then you write that, okay? Where it is? Upon page number 6. Perusal of the pleadings. It is notice that the vehicle oblique dumper bearing registration number AS01JC. No, the vehicle involved in the said application, said accident, sorry, is identifiable being dumper bearing registration number, right? Registration number AS-01JC/6625. Para 3, huh? Comma. The prima facie, the petitioner may not be entitled for ex gratia compensation in view of the fact that the petitioner had an remedy under the law, remedy available under the law. Stuff. Considering above and consider next the petitioner appears to be conscious of the above and decided not to appears to have conscious of the above and decided and not interested in pursuing the what I said, petitioner present writ petition, please do. Not interested to pursue the present writ petition, accordingly, writ petition. Then dismiss for non-prosecution. We'll just say non-prosecution. This item 24.
Item 24.
My lord, matter pertains to, my lord, correction of lane record, my lord. Instruction, the notice has been issued and the next date is fixed on 11/2/26 for appearance of the parties, lord.
So
That
you
is-
appear,
Yes, my lord.
we'll close it. We'll close it.
Yes, my lord, as per my lord, I have filed an representation.
No, we'll see.
11/2
On the
is the
basis
date.
of this, we'll close it.
Yes, my lord.
Heard Mr.
A. Gohai.
A. Gohai, learned counsel for the petitioner. By filing this writ petition, the petitioner has prayed for only one petitioner,
Yes, my lord.
prayed for correction of what?
Lane record, my lord.
Correction of lane record. In the light of the order dated 23/08/1985, issued by the circle officer, Dispur Revenue Circle in mutation case number 849/1985 to 86, whereby the petitioner's name had been, when the land has been mutated in the name of the petitioner in respect of the plot of land measuring 1 kata, 16 leche, covered by dag number 57.
My lord, 2 kotha 7 lesa, my lord. Total,
Huh?
land. Total land, my lord, 2 kotha 7 lesa. There are 2 dark number and 2 pata number.
Okay, 2 kata, 7 leche, huh? In dag number
Dark number 56 and
57.
57.
KP patta number 30,
30, my lord.
56 and
Dark number 56 and
57,
57.
and KP
Cup.
patta number 30
30.
in
Revenue
under
village, Bormotoria.
under
Beltola
village
Moja.
Barmotiria, Beltola Moja. Guwahati,
Yes, my lord.
Guwahati. Please stuff. Next para. Mr. SS Roy, learned learned State Council, huh? By placing the copy of the instruction that is 17/1/2026
11/2000.
submits that this is patta number is something different.
My lord, subsequently, my lord,
It has been changed.
my lord,
Therefore, the-
Then we'll say that
new,
submitted that
it is a reflection.
as regards the correction of land records, a notices have been issued to all the claimants, including the present petitioner, which is scheduled to be heard on 11/02/26,
Yes, my lord.
2026. Mr. Having considered that the respondent authorities, next para, have issued a notice for hearing to the claimants for correction of the land records, including the petitioner, and as agreed to by the learned counsel for the parties, this writ petition. No, as agreed to by learned counsel parties, I deem it appropriate to dispose of writ petition as no surviving issues. There's no surviving cause to be adjudicated upon list of. However, the respondent authorities would proceed with the hearing on 11/02/2026 for correction of the land records of the petitioner as indicated by the notice dated notice dated 09/01/2026 and pass appropriate orders. The writ petition states disposed of.
Obliged, my lord.
The letter to the department with my opinion that no, already writ petition has already been dismissed by this honorable court. And no appeal is preferred by the.
Allowed, not dismiss, allowed.
Allowed.
My lord, recently, the civil engineer construction taken over the SARS recently and already moved. Today, they informed me that they've moved oil, bringing from the Aijal. So, my lord,
Monday,
10 days.
I think Lordship, Monday Lordship is there. Oh,
10 days.
10 days, my lord.
Or will allow the IA
yes.
or what? What do you say?
Your lordship, please, my lord.
In fact, my learned friend has also shown, my lord, he has also given an opinion that BG may be released.
In that case, then we'll give, let us, as I indicated last time, you have given an opinion,
Yes.
then it's okay.
Whenever Lordship is sitting next, my lord.
After 10 days.
Yes.
After 10 days, my lord.
Heard Mr. Ken Chaudhary, learned senior counsel, assisted by Mr. A. Gautam, learned counsel for that. Straightforward. No, Mr. A.K. Datta, learned CGC, submits that further 10 days time may be granted to after an instruction to place the instruction as he has already communicated by communicated with his opinion to release the
BG, bank guarantee.
release the BG to the authorities. Mr. He is expected to receive the instruction within 10 days.
After 10 days.
This matter is prayed for by Mr. Datta, the CGC. On after 10 days.
Yes, my lordship will give a date, my lord.
After 10 days, you just give the date after 10 days.
Aji hol. Let it be on 9th, my lord. February is a Monday.
9.
Huh? Okay, 10. Deep reply.
My lord, would look at the order of 2011.
Let's say,
Some issue as to what is the applicable rule was, my lord, instruction was to be sought.
sought for, if it directed to file additional affidavit, Lordship, I pray for some more time to file the affidavit, Lordship. Some queries or
11 in the month of November, we have granted you.
2 months gone by, my lord.
What to do?
kindly allow me to 2 weeks time, Lordship.
2 weeks, my lord. 10 days maybe maximum, my lord. Because otherwise the issue is boiling down to only that point. Lordship had heard at length, otherwise the issue. That what is the eligibility course to be done in respect of promotion, which we said that we have already done. They say it is the MOBC course, which is not specified in the recruitment rule. So how that course came about is the only thing that came you to.
Okay.
verify.
Third, Mr. B. Pathak, learned counsel for the petitioner. Next, MS S. Barua, learned CGC, submits that she may be granted further 10 days time to 2 weeks time to file additional affidavit as directed on 20/11/2025, as she could not file due to her personal difficulty. Considering above, let this matter be listed. After 2 weeks on
17 February,
hearing day,
17 February, Tuesday, my lord.
17/02/2026, on which date, it is made clear that the affidavit, additional affidavits directed to file shall invariably be filed on or before the next date.
Matter,
Kindly ensure that it is filed.
matter would remain part heard, my lord.
Matter remains Matter shall remain part.
Deeply online.
Yes, Sharmaji.
May it please your lordships.
Yes.
My lord, that affidavit which I have filed, it is in the record, lordships. Now, lordships, on the last occasion,
Additional affidavit filed by respondent number 2.
that
Oh,
reply.
affidavit in
that-
reply,
that
yes.
Reply, lordship.
Yes.
Now, lordships, on the last occasion, lordships, this, my learned friend also furnished a copy of master plan for Guwahati Metropolitan Area 2025, lordships. Lordships, in this notification, lordships, notice for publication of the master plan and the zoning regulation 25 for Guwahati. Lordships, it is notified that new final master plan and zoning regulation 25 for Guwahati prepared by Guwahati Metropolitan Development Authority is hereby published for operation with effect from 7/7/2009.
From where you are reading?
Lordships, this is
It's required, he is lacking, so.
Where is?
lordships.
You
they
tell
have-
us the facts and your grievance.
Lordship, I belong to 32 Harapur Gao Panchayat, lordships. Lordships, I purchased the property from Satyavati Kakoti, lordships, in 2016 to 2023, lordships. Altogether 5 deeds. Lordships, Satyavati Kakoti, lordships, she applied for
Yes.
RCC construction, lordships, and accordingly, lordships, this RCC construction G+4 was granted to him in 2006. Lordships, at that time, she completed her construction, and while construction was made, lordships, at that time, lordships, it was supervised by the 32 Harapur Gao Panchayat, lordships. I come within the purview of Harapur Gao Panchayat. Lordships, then she proposed to sell out the property, entire property. Then I started buying from 2016 to 2023, lordships. Altogether, 5 sale deeds completed, registered sale deed, and accordingly, I purchased the entire building, G+4, lordships. Now, lordships, this 2 private party, lordships, to whom I have made the party, they have lodged the complaint, lordships, before the GMDA, lordships, on 27/2021 and 4/8/2021, lordships. And now, lordships, on the basis of that complaint, lordships, a letter was issued to me, lordships, that is annexed
Where is the complaint?
a complaint, lordships. That complaint, it is not furnished to me, but I received the notice, that is, lordship, page 80, lordships. That
Page 80.
page 80, lordships.
You're challenging that notice.
Lordships.
Are you
that-
challenging that notice?
That order I am challenging, lordships. Subsequently, order was passed. Page
Is-
80, lordships.
Huh.
That is 16/8/2021, lordships. That submission of NOC, approved drawing, and other relevant documents. Lordships, I was directed to submit all the documents, and accordingly, lordships, page 81, lordships, I submitted the documents, lordships. That NOC, approved plan, and other relevant documents. Lordships, thereafter, lordships, Then a show cause notice, page 83, Lordships. Page 83, dated 19/5/2023. It was
This
issued.
is Messrs. Takuria Auto Wills.
Wills,
okay.
it is my property, Lordships.
Okay, then
Lordship, then thereafter, Lordships, I submitted the reply. Thereafter, show cause notice issued under section 87 and 88 of the Guwahati Metropolitan Development Act 1985, Lordships. That is page 83, Lordships,
Hmm.
dated 19/5/2023, Lordships. Lordships,
yes, then
then Lordship, on receipt of that show cause notice, Lordships, on 1/6/2023, Lordship, page 84,
now the
I submitted the.
just wait. Stop the unauthorized construction. So close to undersign within 10 days from the receipt of this is to notice to as to why the regular. Yes,
Lordships, then Lordships, on receipt of show cause notice, Lordship,
you filed this.
that I have submitted reply on 1/6/23, page 84, Lordship. Page 84, and I have specifically stated in my reply that I come within the purview of Harapur Gao Panchayat, not under GMDA. And page 85, Lordship.
Where it says,
That I have a plot of land measuring at Tharapur under Mauja Ramkarani, district Kamrup Metro. I am being to 32 number Tharapur Gao Panchayat. Thus, I am governed by Assam Gao Panchayat RAS Act 1994 and bylaw of the Gao Panchayat for construction of Assam type RCC building and boundary wall within the territorial limit of the Gao Panchayat. I have clearly stated in my reply.
when did you apply obtain the approach to 2002 drawing plans from so approval NOC was given. Approval was NOC and issued NOC on
NOC it was given on
2006. Then
2006. And here I have categorically
according
mentioned
to
in my
values of
reply,
the city of-
and also in page 85, that bottom paragraph, Lordships. Bottom paragraph, here I have stated, I categorically state that the land and building in the instant case does not fall either within the Guwahati Metropolitan Development Authority or Guwahati Municipal Corporation. As such, of show cause notice is exercised as jurisdiction not vested it by law, have failed to exercise adjudication so vested and have acted in the exercise of jurisdiction illegally and with material irregularity. And Lordships,
yes, then
Lordship, I have prayed for to close the issue, Lordship. Then, Lordship, this order, it was issued on 11/7/23, page 87. This is under challenge before this honorable court. Here, Lordships, they have specifically stated regarding section 88 lordship. Now lordships, when when focus notice was issued, when I have submitted the reply, then lordships, under section 88 of the GMDA Act, it was the duty of the GMDA to give an opportunity of hearing, and it is clearly mentioned in section 88, lordships. And then only this order can be passed. Now, lordships, prior to passing this order, no opportunity of hearing was afforded, lordships. And as thus, this section 88, lordships, it is violated by the GMD authority, lordships. And it is under challenge, lordships.
Without any setback and without any valid permission or any which is examined carefully after you have carried out unauthorized without obtaining any. Yes.
Lordships, now.
So according to you, this order has been passed without hearing you
Without hearing me, lordships.
in violation of section
88, lordships.
88 of 88 of
Lordships.
GMDA Act.
GMDA Act, lordships.
Then
Lordship, this GMDA Act 88, subsection 1, lordships.
85 or 88?
88, lordships.
It is mentioned as 85.
88, lordships. Under section 88.
It's
Lordships,
violation of section 88
88,
without
lordships.
hearing.
Here it is.
Number two.
Here it is, lordship clearly
That is
mentioned,
number one ground. Number two.
no such order shall be made,
No, it's okay. We'll read later.
lordship,
There's violation of section 88
of
because
GMDA
you
Act
have not been
1985,
heard.
lordships.
Number two. Any other ground?
Lordship, then after lordship, this affidavit in opposition was issued by them, and you have given the reply. Now, lordships, lastly, lordship, they have taken the stand that this honorable court directed to submit an affidavit, lordships, and accordingly, lordship, that affidavit, it was submitted on 1/12/2025, lordships. And in that affidavit, lordships, one report is submitted, lordships, page 157, lordships. In this affidavit, lordships, there is mention regarding the
One.
page 157 of their affidavit, lordships. This is the report, lordship. The master plan and zoning regulation for metropolitan area 2025 came into effect with effect from 7/7/2009, which included Tharapur revenue of village covering the area of 32 number Tharapur Gaon Panchayat. The government of Assam has published the said master plan by order dated 9/6/2009.
GMDA Act
Lordship, this is the
1985.
This is the master plan and zoning regulation for Guwahati Metropolitan Area 2025, lordships. Now, lordships, on the last occasion, lordships, this my learned friend also produced the copy of master plan for Guwahati Metropolitan Area 2025, lordships. Now, he also furnished the copy to me, lordships, and lordship, in this, lordships, here it is mentioned notice for publication of the master plan and the zoning regulation 2025 for Guwahati. It is notified that the new final master plan and zoning regulation 2025 for Guwahati prepared by Guwahati Metropolitan Development Authority is hereby published for operation with effect from 7/7/2009. The final master plan and the zoning regulation, together with all relevant papers and maps, may be inspected free of cost during office hours at the offices of the Chief Executive Officer, Guwahati Metropolitan Development Authority, the Deputy Commissioner and Kamrup, the Polasbari and
This report is against you,
Lordships,
irrespective of the building.
Lordships.
This report,
Lordships, here it is mentioned, this
no,
Polasbari.
is this report pertains to your building?
Lordship, it is not pertinent to me, Lordships,
Hmm.
because here it is mentioned, this line is important, Lordship. The Polasbari and North Guwahati Revenue Circle Office, Guwahati Municipal Corporation, and North Guwahati Town Committee, copies of the master plan and zoning regulation and said copy of report and maps are available at the office of the Chief Executive Officer. Lordship, this Polasbari Revenue Circle and North Guwahati Revenue Circle. Lordships, I am under the Azara Revenue Circle. Whatever deeds, Lordships, it is executed, Lordships. It is clearly shown in the cell deed that
It's okay, but then now that has been, the area 20 has been issued with effect from 09/06/2009.
Lordship, this Azara Revenue Circle, it is prior to that, Lordships.
What Athara?
Azara Revenue Circle. I
No,
am,
this is Darapur, we are reading 157.
Lordship,
The master plan zoning so and so came into force with effect 7/7/2000, which include Darapur Revenue Circle. Page 157.
Lordship, no, this is the notification, Lordships. This is the notification. Here it is clearly mentioned, Polasbari and North Guwahati Revenue Circle.
Where reading from?
Lordships, that 40, yes.
It's okay. We are reading at page 157. First you read this. Master plan and zoning regulation for Guwahati Metropolitan so and so come into force with effect, so which include Darapur Revenue Circle, village.
Lordship, this is the same, Lordships.
Ah,
Which included Harapur Revenues Village,
hmm.
covering area Harapur Gao Panchayat. The Government of Assam had approved the published of the said master plan, height order dated 9/6/2009. It is clarified that the said property was included in 1986 master plan and zoning regulation for Guwahati
1986.
1986, at the time when 32 Nang Dharapur Gao Panchayat issued the building permission, NOC and approved plan on 30/11/2006. The area was still under the jurisdiction of GMDA and covered by the master plan. In view of the above, it is imperative that the said site under question was under the purview of master plan and zoning regulation of Guwahati metropolitan area, where the development permission is to be obtained from the GMDA. However, certain construction permission outside the GMC area were granted by the respective Gao Panchayat, as it is also a building permission issuing authority in rural areas. As such, GMDA restricted its action only to those construction that were clearly identified as new and unauthorized, having been raised after the publication and enforcement of Master Plan 2009. Accordingly, based on a complaint and subsequent site inspection, GMDA issued the demolition order on 2023, file letter number so and so. Now, Lordships,
You
after all,
read again. Last, the order pertain to
the-
structure found
the-
to be recently built and appearing as a separate additions situated almost adjoining the boundary wall. On the western side covered CIJ along with RCC toilet at the ground floor concerned in rear setback adjoining the main building. These constructions were in clear violation of so and so, so and so. Huh? Then
Lordship, now this report is based on these Lordships.
huh,
But this report is disputed Lordships. Lordship, first, before preparing this report, Lordships, they ought to have gone through notification, that is the that is the master plan for Guwahati Metropolitan Area 2025, Lordships. Now,
huh.
Lordships, my all cell ditch, whatever I have, 5 cell ditch, it is of Azara Revenue Circle, not Polasbari and New Guwahati, Lordships.
Hmm.
And this Azara Revenue Circle, it is an independent revenue circle. It is not subordinate neither to the Polasbari nor to the New Guwahati, Lordships.
Yours is
Azara Revenue Circle. My all sell this Lordships may be perused, Lordships. I have
Hazara Revenue Circle.
Lordships.
Then
Azara Revenue Circle.
they are
but
saying what? What they are saying?
They are saying Polasbari and North Guwahati Revenue Circle. And my revenue circle is not subordinate to Polasbari or North Guwahati.
Then
It is
this,
an independent Lordship.
Hazara Revenue Circle is Danapur Panchayat, falls under Darapur Gaon Panchayat.
Lordships.
Then
Lordship, as such, this GMDA cannot enter into my area, Lordships. Because once they entered into my area, it is exceeded their jurisdiction, Lordship, not vested in law, Lordships.
no.
And also, Lordships, this 88, there is a 88 violation, Lordship, section 88 violation,
That you have said so.
Lordship.
This is, I am not clear. What you are saying?
Lordships, I do not come under the Polasbari and North Guwahati Revenue Circle. Whereas my revenue circle is Azara Revenue Circle. My all shell deeds are here, Lordships.
So this, why they are in report, they say that falls under the Darapur Gaon Panchayat, page 157.
Lordship, that is their report, Lordships. That is their report to cover up their case, Lordships. But that report, before passing that report, Lordships, there is no hearing afforded, Lordships.
What
This is
is
the-
the notification says? You said not some notification, you are reading some notification,
Lordship,
saying what?
no notification, Lordship. Notification of master
Master
plan.
plan, what is 2025? Yes, 2009. Yes, then
Here it is clearly mentioned Polasbari and North Guwahati Revenue Circle. Second,
action power
second
conferred by the
paragraph.
so and so the MDEC, the Devati Metropolitan Development is listed to the following notice regarding publication, new finance master plans and zoning regulation. Final master zoning rule for Guwahati Revenue, it is published for operation with 77. The final master plan and zoning regulation with all development may be inspected free of cost during the office hours at the office. Deputy Commissioner Kamruk, the Polasbari and the North Guwahati. See, the final master plan and zoning regulation together with all relevant papers and maps may be inspected free of cost during office hours at the offices of the Chief Executive Officer, Deputy Commissioner, Kamrup, Palasbari and North Guwahati Revenue Circle, North Guwahati Town Committee, copies of masterplan zoning and soft copy report maps are available at the office of Chief Executive. No, it is, you can, this number 2 is all relevant, maybe for inspection only. For inspection, these offices, CEO, right?
Lordship.
Deputy Commissioner, Kamrup Metro, Palasbari and North Guwahati Revenue Circle offices. In these offices only you have to inspect, you may inspect.
I make.
It doesn't say so.
But
That
lo-
this Hazare and all those things is not, cannot be under there.
Lordships,
It only for inspection. You read the serial number 2.
Lordship, this is the gist prepared Lordships out of the entire things.
Not
Lordship.
just, what does it say? It is notified new final master plan and zoning regulation 2025 for Guwahati, prepared by Guwahati GMD is hereby published for operation with effect so and so. Then read serial number 2.
The final master plan
With all relevant papers and maps may be inspected free of cost
free of cost.
from these offices. In these offices, you may inspect free of cost. That's all. It doesn't, this notification, it doesn't say that this is only for Palasbari and North Guwahati.
Lordship, a second line is very clear, Lordship. The Palasbari and North Guwahati Revenue Circle offices,
Ah,
Guwahati Metropolitan, Guwahati Municipal Corporation,
ah.
and North Guwahati Town Committee.
These are the offices where you can inspect, right? These are the offices where you can inspect the documents, this master plan and other maps and that thing. Am I correct? It doesn't say this Palasbari and North Guwahati is only is included in the master plan or zoning regulation.
Lordship,
It only says they have issued the master plan and zoning regulation. Then these, the documents, master plan, maps and everything can be inspected free of cost in these offices. CEO's office, right? Deputy Commissioner's office and the Palasbari and North Committee Revenue Circle offices it says.
Lordships, as
So it doesn't say that it should be, this is only the Palasbari and the North Guwahati which falls under the zoning regulation.
Lordships, if I would have been fallen under the GMDA Lordship, then this GMDA authority ought to have also mentioned that Azara Revenue Circle. But here, Lordships,
No,
Azara
no.
Revenue Circle.
It's
is not
only, you
mentioned.
just read it again and again, please again read it. That's why I was wondering why you are relying this.
The Deputy Commissioner.
These are the offices where you can, a person can inspect the documents after the notification of this master plan and zoning regulation. It may include so many other areas, the zoning plan, regulation. Master plan and zoning regulation may include so many other areas, but these are the offices where you can inspect. Whether yours falls under that, not that you are not clear.
Lordship, in this respect, Lordships,
That's all.
I will make an inspection in the offices, Lordship, then I will submit a report before the Honorable Court.
No, we're
And
not,
accordingly, Lordship,
we're not interested.
10 days may be granted,
Nothing, sir. Do you agree what I'm saying?
Lordship. It is
If you agree, nothing there. You are trying to project. As I said, I was wondering how you are trying to project that this is only includes the master plan and zoning regulation only includes the Palasbari and not Guwahati. I said, what from where you are reading?
But let the order which was passed under section 80, it is violation complete.
That I will, that is the one part. That's why I said number 1. This is number 1. Number 2 is this one, which it's falls flat.
Lordships.
So we'll see. Let's section 88.
88 Lordships.
Where is this? So GMD Act. 1988 or 85?
88 lordships.
85.
Even
sections are 87 and 88.
It is, you have mentioned 88 in
Act
the
is 85,
documents.
but section is 87 and 88.
No, that's why I'm saying, you said section 88,
88 lordships.
GMD Act 1985.
88 lordships.
Are, yeah.
88 section.
Section 88, but the Act of 1985.
Lordships.
Yes, that's your. Just read it.
Lordships. That operative portion are complete. I will do.
No, the section, the provisions which you are relying.
Lordship, section 18, power of demolition of building where any development has been commenced.
No, which provision you are relying?
88 lordships.
You read 88.
88. Where any development has been commenced or is being carried out on or has been completed in contravention of the master plan or development scheme or without the permission, approval or sanction referred to in section 25 and section 20 and section 30 of the Act, or in contravention of any conditions subject to which such permission, approval, sanction has been granted, the authority may, in addition to any prosecution that may be instituted under the Act, make an order directing that such development shall be removed by demolition, filling, appealing, or otherwise by the owner, occupier, manager, or any person on at whose instance the development has been commenced or is being carried out or has been completed within such period, not being less than 5 days or more than 30 days from the date on which a copy of the order of removal with brief statement of the reason thereof has been delivered to the owner, occupier, and manager, or the person at whose instance the development has been commenced or is being carried out or has been completed as may be specified in
Where is the requirement of a personal hearing?
personal hearing, lordships. That is the last. That no such order shall be made unless the owner, occupier, manager, or the person concerned has been given a reasonable opportunity to show cause why order shall not be made.
You have given page 83. Notice was given.
Lordship,
That is
But
called
that-
opportunity of hearing is there. So cause, once so cause is notice is issued. Thereafter, you have replied the so
replied,
cause.
lordship.
Then
After that, lordships, I should have been
where
called
is the
for
personal
hearing.
hearing?
That opportunity, reasonable opportunity to show cause.
So cause.
Show cause,
That's
lordship.
all.
Lordships,
It's not that they have passed the order directly without giving you a so cause notice. First, number one, you have been given double opportunity. One is to place the documents, which you have placed it.
placed.
Being not satisfied, they have given you so cause notice under section 88, which you have read. Thereafter, they pass the order placing on you wrongly or rightly. So there's no question of violation of natural justice.
Lordship, this complaint was.
And the report you have not, when it comes to your, knowledge, you have not challenged the report, right? The only your ground remains is you have not been provided opportunity of hearing. Opportunity of hearing, not necessarily a personal hearing. But in this case, explicitly in the under the Act, the statute provides for so cause, which you have been already been given. And it is clearly found on the facts and record that the construction and all other thing is a new thing, which is beyond the recent one. Whereas you have obtained the NOC, from whom you have purchased, not you.
Lordships.
That has been obtained in 2006. whatever they have constructed, they have clearly said in the report that equally the Gaon Panchayat under the law can issue a NOC in respect of rural areas, right? Now it falls under the urban, I mean, whatever, GMDA or metropolitan, falls under the zonal regulation, right? Now you are found to have constructed recently without permission. Nobody has stopped you to seek for permission. You have not done so. So you are not challenging the finding of the, I mean, report of the authority that you have started new construction and all this violating without any NOC. You could have asked for a permission because your permission is by your, I mean, seller, the original owner. I think
Lordship,
it's
Lordship,
of no use. Nothing. It will be unnecessary to hear again. That's all.
Lordships, now, Lordships, this, I have met the private parties who have lost the
It's
complaint.
okay. We're not.
Lordship, those
We're not
complaints,
required to hear them.
those
There is
complaints,
a report, sir, already.
those complaints have not been furnished to me,
It's
Lordships.
okay.
And I have right to get the copies,
No,
Lordships.
don't then.
And also, Lordships,
Thereafter, there's a report. Whether this Darapur, what is it called? Darapur Gaon Panchayat falls under this or not. There's a report.
Lordship, in their affidavit, Lordships, here this page 154, some bamboo projections were present from the ground to the fourth floor. Lordship, from the-
To illegally
Lordship, this
they
was,
construct.
Lordship, no, this was kept standing because
We don't
certain-
know.
Lordship, certain nets were there, dirty places were there for removal of all those Lordships. It is not for the new construction, only for cleaning the
We
wall.
don't know.
Lordships.
We don't know. Report is there. See, issue whether this Darapur, the Gaon Panchayat falls under this metropolitan, where the master plan and the zonal regulation will regulate, right? Now it is admitted position that now it falls under. Earlier it was outside, but after 2006, 9, by 2009 it falls under this. Now, and admittedly you have purchased the land and the building property from a original owner who has obtained the NOC from Gaon Panchayat back then. Now you want to have a new construction, which you ought to have asked for obtained a NOC. Nobody has stopped you. You could have asked for NOC.
Lordship, as on now, Lordships, I am paying the revenue and other taxes to
Doesn't
the
matter.
Gaon Panchayat, Lordships,
Doesn't matter.
not to the GMDA, Lordships.
Doesn't matter.
And they are collecting the revenue.
Doesn't
Lordships.
matter. Now, well, what we have to decide the legality and validity of the order which has been impugned here.
Lordships,
So that's why I specifically ask you, your first is violation of sections 88. I find that there is no violation of section 68 because you have been provided an opportunity. Number two, which you have tried to raise, that land doesn't fall under the Balishapara, Balishapara and North Guwahati. It doesn't say anything as per the notification. It says you can inspect the documents free of cost in these offices. Therefore, your submission falls flat. Okay.
Lordships,
And any other ground? Still, I am
Lordship-
asking any other ground.
Lordships, I have already submitted a citation of the Honorable Supreme Court, Lordships. That is Municipal Corporation Ludhiana versus Inderjit Singh and another Lordship.
Saying what?
Lordships, this is regarding the construction, Lordships.
Yes.
That is, already I have, it is in the record, Lordships.
What does it say? You just tell us.
Section, the paragraph 15, Lordship.
Hmm.
The opinion of the Honorable Supreme, the notice was vague and lacked any description of the property. The corporation did not disclose how much area of the property was the subject matter of unauthorized construction. Since a sanction plan existed, it was obligatory for the authority to categorically state the precise area, if any, that was unauthorized. Principle, a demolition order must specify measurement, extent, and reasons. Mere labels like unauthorized are insufficient. Lordships, already I have submitted lordships.
It's not here.
Otherwise, this can be.
Brief of the Supreme Court judgment. Huh? Where is,
Paragraph 15, lordships.
this is reported, reportable. Municipal Corporation, Ludhiana. Where?
15 lordships, 1-5. Fifteen and 17.
Appellant further acted arbitrarily insofar as it demolished the structure despite pendency of suit. We would assume that the order of injunction granted for limited, but it is expected with statute of the act, thereupon informing their court. Further, the notice was vague. It did not contain any description of property, how much area of property was subject matter of unauthorized construction had been. It is not in dispute a plan for construction of building or section. It was therefore obligatory. A plan for construction building was sanctioned. It's a completely, anyway. That's all.
That's all.
Yes, that's it.
Just two things I am showing.
Let us see whether what sort of illegal construction we have been. Let us see the notice, page 83.
Of the writ petition. Page 19. Granted by the Dharapur Gaon Panchayat. Lots of specific areas has been mentioned there. And more specifically, if lordship comes to page 23.
Ground floor, second floor,
Or
third
fourth
floor,
floor.
fourth floor.
More
Yes.
specifically, page 23.
Hmm.
Page 23 is the drawing.
Yes.
The first thing your lordship will notice, on the left-hand side, lordship, the building construction and the boundary is parallel. If lordship looks at the top portion, lordship will see one figure 1800. One line has crossed the figure.
just below 10400.
Hmm.
1800. This is the setback on the back side.
Hmm.
This is the approved plan. And just on the right hand side, Lordship will see one figure 2400.
Hmm.
This is the right hand side setback. Now, if Lordship comes to my second affidavit, Lordship, page 158.
Just before that, yeah, let's see. One zero?
Lordship noticed page 23. Now, if Lordship comes to page 158.
Yes.
Lordship, in the approved plan, on the back side, Lordship, the setback was 1800. Now, in the recent inspection report, it is found to be 1200. One.
Hmm.
On the top, Lordship, just one figure, letters are there, Lordship, upper floor line.
Hmm.
Lordship will see the setback 1200.
Hmm.
At the same time, Lordship will also see ground GF line, Lordship. That is the toilet constructed on the wall.
Hmm.
And on the left hand side, Lordship will see in the approved drawing, the boundary wall and the.
No, it's okay. Where you have you mentioned in your notice?
Yes.
One, page 83?
Yes, it's statement there. But this is the inspection done in terms of order passed by the court. And the petitioner was also present. So these are the specific deviations. Now, second thing, your Lordship has already.
Yes, manner of development construct. Ground floor is constructed merged with the plot boundary. Rear back setback has been deviated by construction of toilet. Is provided.
Page 53 has been. See, 153, Lordship will get the boundary figures, Lordship.
It's okay. We would like, he's saying that no, relying on the Supreme Court, and what he said that it's not been specified. It has been specified, manner of development construction.
Now, second.
Ground floor is constructed merged with the plot boundary. Rear back seat has been deviated by construction of toilet.
Second thing, Lordship,
Where
so far as granting of opportunity of hearing.
Hmm.
Section 88, Lordship, also speaks about reasonably so called things. So there is no specification as regard giving any personal hearing.
Hmm.
So initially he was issued a so-called notice, Lordship, for production of document.
Hmm.
Subsequently, a so-called notice was issued under section 87 and 88.
Hmm.
And lastly, Lordship, at page 87 is a demolition order. So in his reply, Lordship, which starts from page 84, herein, Lordship, he has clearly given his reply, submitting all his points. Nowhere it has been stated, please kindly give me an opportunity of personal
It
hearing.
only said it doesn't fall under. Darapur falls under Gaon Panchayat, not under the metropolitan adjoining area.
Now, if Lordship comes to the notification, Lordship, notification of 2009.
Here,
This is the notification,
85 is there, Act of 85. Huh?
1985.
Yes. That is okay, notification.
This is the Gazette notification of declaring the master plan area, Lordship. This is 9 July 2009.
Hmm.
If Lordship comes to the second page.
Ajargaon.
Villages, Lordship. Ajargaon and Dharampur. And Lordship, if Lordship comes to the Moja Dakhin Rani, Borjar Kahikuchi Jugipara. Now Lordship, Borjar is the airport and Ajara is a place, Lordship, between the Guwahati city and Borjar.
No, where you are reading? Next page.
Second page. Lord.
Hmm.
Second page, in the Jalukbari Moja, Lordship will see Goralgaon, Ajargaon, Rampur.
No, just wait. Jalukbari,
Yes.
Goralgaon,
That is Ajara.
Jalukbari,
Yes. Jalukbari is the Moja.
Goralgaon,
Ajara, Rampur.
these are villages. Where is Dharapur?
Third one is Dharapur, Lordship.
It is Dharampur.
Wrongly Lordship given, it is Dharapur. If Lordship comes to the 2 lines above Lordship, Borjar is there. Borjar is the airport, Lordship.
Hmm.
Now, is Ajara is a place, Lordship, between Guwahati and Borjar.
Hmm. Then Dharapur?
Third one is Dharampur, Lordship. It is written as Dharampur, but it is Dharapur, Lordship.
No, it doesn't indicate the Gaon Panchayat. Dharapur Gaon Panchayat. So your village is?
Harapur Gaon Panchayat.
No, the Gaon Panchayat is something. Where is your village?
Harapur Lordships.
Huh?
Harapur Lordships.
Dharapur village.
Lordships.
So there is no Dharapur.
Third one is Dharampur. The one M has been wrongly
It is Dharampur.
written as Dharampur, but there is no such village as Dharampur, Lordship. It is only Dharapur.
Dharampur is separate place is their Lordships.
Hmm?
Dharampur is their Lordships. It is under the Palasbari Lordships.
Palasbari?
Palasbari Lordships. But my village is Dharapur Lordships. In my each schedule of land, shall deed Lordships. Village Dharapur, Mauja Ramsarane, Ajara Revenue Circle. My each shall deed it is there. Dharapur.
Moja?
Mauja Lordships, Ramsarane.
Huh?
Ramcharani.
Where it is? Dharam?
Ramcharani Mauja. Ramcharani. Ramcharani
Ram Sarane.
Lordships.
Where it is?
It is, that is Mauja. We come under the Mauja Ramcharani Lordships. It is,
He said this is Jalukbari. Moja Jalukbari.
I am not in Jalukbari Lordships. My
Moja Jalukbari.
Mauja Ramcharani Lordship. My Mauja is Ramcharani.
Where do you get it?
That is
Page?
in the cell deed Lordship, any cell deed Lordship, page 49 Lordships. Page 49. Page 49.
Indeed.
Page 49 Lordships. Bottom Lordship, situated at Revenue Village Dharapur, Mauja Ramcharani, under Ajara Revenue Circle, District Kamrup Metro Assam.
Ram Sarani.
Lordships.
Ajara Revenue. Kamrup Metro.
At that point of time, Lordship, it was metro. Now it is rural. Now, Lordship, it is available everywhere, Lordship.
Lordships.
It is
No, he said this Dharapur, Moja, Ram Charani. This Moja is Jalukbari, which you have shown.
Jalukbari boli Mauja likha আছে. Yes, Lordship. Now, Lordship, it can be Google, Lordship. Everywhere it has been mentioned as Dharapur and Ajara are both located within the Kamrup Metropolitan District and are part of the Greater Guwahati Metropolitan Area in Assam.
The problem is the Moja is different, Ram Charani, completely different, new this thing. There is no Ram Charani also. Silasin Duri Gopa, Pab Bangsar, Dakin Rani, Chayani, Jalukbari, Beltola, Ulubari, Guwahati. How do you settle it? He said he doesn't fall under Jalukbari.
That is not correct, Lordship. So there may be some discrepancies in this notification. But that does not mean, Lordship, Ajara Revenue Circle,
No.
both Ramsarani and
That
Jalukbari
is
comes
the
under the
best
Ajara
part.
Revenue.
What he's saying that my village is Darapur, falls under the Ramsarani Moja, which is not under Jalukbari. So Jalukbari, there's no villages called Darapur. Maybe let us assume him that the Dharampur is wrongly mentioned in Dharampur.
This is Ajara Gao, Lordship.
Dharampur Lordship,
Azara means what? You are Azara.
Ajara Lordship. Dharampur is there, Dharampur.
Azara Gao.
No, our village is Dharapur,
Ha.
revenue village, Ajara.
Ha.
This is Ajara, is revenue village means Ajara village, Lordship. This is revenue.
What does it say? From where you are saying?
Lordship, my schedule itself is very clear, Lordship, page 49.
Ah, Azara Revenue Circle.
Revenue village, Dharapur, Mauja Ramsarani, Ajara Revenue Circle, district, Kamrup Metro, Assam. In all my cell deeds, it says, Lordship, that Dharampur, there is a village, it is in the Palasbari Lordships. I do not come under the Palasbari Lordship. I come under the Azara Revenue Circle. Dharampur is there, Lordships.
Azara Gao is there in Jalukbari. Jalukbari Moja, there's Azara Gao is there.
Second two.
Lordship, my village is Dharapur. In cell deed itself, it is clearly says, all the cell deeds.
Cell is in which year?
Lordships, this cell deed, Lordships, it is in 2023, Lordships. Yes,
Huh?
this was executed in 2020, 31 January.
I think
2020.
you need to clarify. You clarify, get it.
So far as other issues are concerned, your Lordship is, I'm think, convinced. Only this issue, Lordship.
This
tomorrow-
issue.
Yes, Lordship. Tomorrow.
Because
after.
his claim is, it has a bearing. He said his village is Darapur, Moja Ramcharani, under Azara Revenue Circle, not Azara Revenue Village. Revenue Village is Darapur. So your Jalukbari, he said, I'm not there. And there's no mention of Darapur village.
I'm satisfying, I will satisfy your Lordship. that
Yes.
This particular.
Tomorrow, we'll
area-
complete it tomorrow. Only
Tomorrow.
with this aspect. All right.
Lord. And also Lordships, against this property Lordships, I have a big amount of bank loan Lordship, about 3 crores.
Can't,
rupees I have
can't
to
help
pay.
it. You
3
should have
crores I-
asked for,
Lordship,
see, if they cannot substantiate that your, this property falls under this thing. Under the master plan and zoning regulation. Ha. Under which for which the notification has been issued, publishing in the official gazette. Then they may not have authority. Right? Although you have not specifically said so, but that we can imply because of your documents which you have annexed. Let us see. Anyway, GMD is there, but then from by notification you explained, clarify, we'll go by the records only.
Lordships,
Yes. Again tomorrow.
Lordships.
We thought we'll dismiss your case today.
He's lucky in fact, Lordship. His case is lingering since 2023.
Heard Mr. R. Sharma,
Lord.
learned counsel by the petitioner, and also heard all of them, huh? Having considered that the claim of the petitioner is to the effect that the name of his revenue village is Dharapur, comma, Moja, what? Moja? Ramcharani.
Ramcharani.
Page, what is page? 49. You just check it from page 49. And under Ajara Revenue Circle
Revenue Circle.
and the gazette notification placed on by the learned Standing Council GMDA, Mr. P. Nayak, indicates that the property of the land of the petitioner falls under Darafur village, Moja Jalukbari, within bracket, although inadvertently it is shown as Dharampur, comma. Learned Standing Council is granted a day's time to clarify as to whether the village Dharapur falls under the Jalukbari Moja. That's all. Is not it? You have to clarify.
The place, the place where the building was constructed, that comes under the JLC.
No. To show that the building constructed by the alleged illegal construction of building by the petitioner is within the master plan and the zoning GMD jurisdiction in terms of the master plan and the zoning regulation 2025. Correct? Because they are contradictory.
But instead of 28 of second.
Third, then in that case, third. Third.
My lord, on undue prayer, my lord.
Ha.
On undue prayer, my lord, item 20, my lord, I could not attend, my lord, extremely sorry. And
I
your
think
lord-
that they we have dismissed.
Yes, my lord, for non-prosecution, my lord, for
Can't
my
help
fault,
it. I
my
have
lord,
signed
client
the-
will suffer, my lord.
Uh,
My lord, may I pray, my lord, for
You file appropriate application, we'll consider. Immediately you file next week, we'll
Again,
consider.
She has to come, my lord, again, poor lady, my lord.
Can't help it. I have already signed. Otherwise, I could have changed it. There's a reason why I'm dismissing.
Yes, my lord.
You are not entitled.
I'm not entitled, my lord.
Ah.
This is undue prayer, my lord, but only poor lady, my lord, she has to
No,
come
that
from.
can, if you are not entitled, how can they? If you say that you are entitled, then
No, that is, my lord, your lordship passed order yesterday.
you file an application.
Your lordship has.
You file an application, we'll consider.
But
All right.
In a similar matter, my lord, your lordship asked the government to file, clear their stand, my lord.
Yeah, we'll see.
I have.
It's
this order.
okay, you file application. All right. We'll consider.